lot of tradition here. And there's a lot of tradition and a lot of institutional knowledge led by a skilled set of ethics counselor, which is Brian, Nicole, and Suzanne. I've worked with these three for the last 7 years on the ethics committee, and they are a real source of institutional knowledge and very helpful. In fact, all three of them in different counties have fan clubs from people that they've helped out and guide through some very tricky and sticky ethics situations. I am going to ask that everybody be patient today by Zoom. This is not the best way to handle an ethics committee. Meeting in person certainly allows a lot more robust discussion and informal conversations and education, and hopefully we'll be able to do that in April if Omicron is flamed out. I think it will. And I look forward to seeing everybody in April. So normally we start with going around the room with folks introducing themselves so we know who's on the committee. We do have 22 counselors and 14 advisory members. But because of the awkwardness of doing this in Zoom, I'm going to call on people down the line and then unmute yourself and unmute yourself and introduce yourself, tell where you're from and kind of what your practice area is, because we do try to get a large variety of practice areas so that we can have some subject matter experts as different ethics requests come into the committee. So let's start with Brian, and then Nicole and Suzanne, and then I'll start calling on people. Brian, why don't you go first?
Sure. Thank you, Eben. So my name is Brian Oaten. I'm your ethics counsel. I've been with the bar since 2007. From 2007 to 2018, I was with the Office of Counsel, handling a lot of the investigation and prosecution of complaints of misconduct. But moved into this role in 2018 and wear a number of hats at the bar, but ethics counsel is my primary hat. So I am here to help you all and answer any questions and just make sure that you all look good. But I'll go ahead and pass it off to Nicole at this point.
Good morning, everyone. My name is Nicole McLaughlin. I'm one of the assistant ethics counsel, and I have been with the bar since 2004. And like Brian, I started in the grievance department, had a dual role. I handled grievances in the morning and then ethics in the afternoon, and now I'm solely in ethics.
Great, thanks, Nicole. Suzanne?
Good morning, everybody. My name is Suzanne Lever. I have been with the bar for 15 years, and I have always been with the ethics department. You may have seen my name on some correspondence. I am also I'm also the staff liaison for the State Ethics Commission. So I am the one that makes sure you do your SEI filing and your education. So if you have any questions about that, please reach out to me. And welcome to the new members, and to the other members. It's good to see everybody.
Yeah. All right, I'm going to go down the counselors in alphabetical order, and I'm going to call on DNA first.
Thank you, Mr. Chairman. My name is David Allen. I try lawsuits when I can in Charlotte. I've been on ethics for quite some time, and it's good to be back and good not to be having to talk today. And I know y'all are all happy I don't have to talk today.
Well, you've got a report to give, David, on, at one point, and I think make a motion. So you'll have to talk a little bit. So thank you. Thank you for stepping in on that role.
Yes, sir.
Tom Anglin from Little Washington. Where are you, Tom? Is Tom on?
I don't see Tom on today.
Okay. Tom's a assistant district attorney down in Little Washington. Judge Julie Bell from Raleigh. Judge, are you on?
I am. Good morning. I am Julie Bell. I am a district court judge in Wake County, the 10th Judicial District. This is my second year on ethics and third year of my first term on the council. My first year I was on grievance, and glad to be here.
Thank you, Judge. Ashley Campbell from Campbell Law School. Where are you, Ashley?
Good morning. I'm Ashley Campbell. I am a new counselor from the 10th Judicial District in Wake County, and I'm a professor at Campbell Law School and also in private practice doing commercial and real estate litigation. Looking forward to working with all of you.
Okay. Andrea Capua. Andrea, you still snowed in?
I am still snowed in, yes. I mean, we can get around, but I'm looking outside. It's kind of dreary here in Boone today. I'm Andrea Capua, and I have been a counselor for 6 years. This is my 7th year. For the first 6 years, I was on grievance, and really enjoyed that experience. And I'm looking forward to being on ethics, because we always hear about the different committees and the different styles. So I'm just looking forward to this, and I'm looking forward to bringing out my the nerd in me. Because I'm in a small town, we have a general practice, and the three, I would say, you know, I wear a lot of hats, but the 3 areas that I primarily focus on, it might sound a lot, but they're very complementary of each other, but would be real estate, domestic, and estate planning. So I'm coming to the table with I think probably 30 years of experience in those 3 areas primarily.
Well, great. Glad to have you on board. I hope you didn't listen to Mac McCarley's gripes about his
I did.
Yeah, you know.
So I want to see if ethics lives up to its reputation.
Well, you know, take Mac with a grain of salt. So anyway, Judge George Cleland from Winston-Salem, I think, right? Judge, you on?
I do not see Judge Cleland today.
Okay, he's probably holding court. All right, Dion Fortner from Smithfield.
Yes, good morning, everyone. I'm Dion Fortner from Smithfield, which is in Johnston County, and this is my 3rd year as a counselor, my 3rd year on Ethics Committee. I'm really happy to be here.
Thanks for all your hard work. All right, Bert Kemp from Pitt County. Bert, where are you? Yep, you got to unmute yourself.
My name is Bert Kemp. I am the counselor for District 3, 3A. It just depends on how you look at it, but it's Pitt County, Greenville. This is my 2nd year on the council, 2nd year on ethics. I am the chief public defender in Pitt County. I'm in the National Guard. I'm a state military judge, and I teach a class at Campbell. And I'm happy to be here.
Thanks, Bert, and welcome back. We've got Kevin Kiernan from Sampson County, right? Clinton?
Office is in Clinton, yes, but actually live in Kenansville and operate in Sampson, Duplin, Onslow, and Jones out in the 5th District. 4th year on the council, 4th year on the Ethics Committee. Glad to be back for another year. Mainly
so are you going to
criminal law?
Are you going to take the moniker of the Pickle Man, since Duplin County is sort of the ground zero for pickles?
We do have right there between Duplin and Wayne with Mount Olive. That is true.
Okay, great. Welcome back. Judge Tom Langan from Pilot Mountain, I think, right? Tom?
Yes, sir. Good morning. I'm a district court judge in Surrey and Stokes counties. That would be Pilot Mountain, Dobson, Mount Airy, King, Danbury, Walnut Cove, if you're familiar with that area, just north and northwest of Winston-Salem. I practiced as a prosecutor for almost 20 years prior to becoming a judge in 2019. So I would say my practice areas are criminal, and here lately a lot of family law.
Great. Well, welcome aboard. I am familiar with that. Camp Haynes out of north of Winston-Salem. I was a camper there and was a counselor there in high school. So welcome.
Thank you.
Takia Lewis from way down east. Takia, where are you?
I'm here.
Okay, there you are.
I'm Takia Lewis. I'm from Mahaski, and that's District 7, Hertford, Bertie, Northampton, Halifax counties. I've been on the council for 4 years and on ethics for 4 years. I'm in private practice with my dad, and I mostly do criminal and traffic stuff.
Well, welcome back. Good to see you. We've got Roy McDonald from Lexington, I think. Roy, you on board?
I do not see Roy.
Okay, all right. Then we've got Judge Dorothy Hairston Mitchell. Judge, congratulations and welcome back.
Good morning, and thank you. I am Dorothy Hairston Mitchell. I am from Durham County. I am in my 5th year on the council, and I have thoroughly enjoyed my work on the council thus far. Y'all keep me busy and working, but I appreciate it. I am back on the Ethics Committee after having left for some time period to go to the Grievance Committee, but now that I'm a district court judge, I can no longer serve over there, so I'm happy to be back. It's good to see everybody. Most recently, before being a district court judge, I was a clinical professor at North Carolina Central. I say that because that is one of the highlights, I believe, of my career thus far. I love working with the students. That was very bittersweet for me to leave that post, but I'm super excited to serve in this new way as well.
Great. Well, welcome back. Good to see you. Now we've got a new counselor, Kimberly Moore, who's I think a federal public defender. Is that right, Kimberly?
Hi, good morning. Yes, it is. I'm now an assistant federal public defender for the past, well, prior to becoming an assistant federal public defender, I was a state and federal prosecutor, so I've moved to the other side.
Great.
I'm new to the committee, and I represent the 10th Judicial District. And the Federal Public Defender's Office for the Eastern District of North Carolina covers from Wake County to the coast, the 44 most eastern counties. And I look forward to being here. I'm excited about this. Thank you.
Yeah, we look forward to your work. I'm a former state public defender out of Charlotte, so I know what you're going through. So welcome.
Well, it's different being on this side.
Yeah, but you'll find it very rewarding. So
thank you.
That's the right side. I just want to make that clear, Mr. Chair.
Now the other.
Hey, Bert.
All right, Gina Morris from my hometown. Where are you, Gina?
I'm here.
Hey.
I am Gina Morris from Charlotte, North Carolina's 26th Judicial District. I'm in the 4-year club, 4th year on the council, 4th year on the ethics committee. I practice family law at James McElroy Deal in Charlotte. Glad to be here.
Great. Welcome back. All right, Mary, right? Mary Oxley from Forest City.
Yes, that, have I got it?
You're muted.
There we go. Is that better?
Great. Yeah, that's better.
Yes, I'm Mary Oxley and I practice in Forest City. That my district is 41, I think. That's Rutherford and McDowell counties. Small counties. We have a very small practice. There's just 2 attorneys in the office. So as one of the previous folks, I wear lots of different hats. So we do a lot of estate administration. I do some guardian ad litem work. I was actually filling in for somebody who was sick for DSS, so I've done some of that sort of work. We do some real estate and contracts and kind of whatever else floats in the door. I have used to be in the DA's office, but not doing criminal or domestic law anymore. So I've kind of worn all sorts of different hats, but I'm looking forward to working with everybody.
Great. Well, welcome. And so the first of the Poisson family, Davis Poisson, we've got Stuart, and this family has a long history of valuable contributions to not only the state bar, but the practice of law. So Davis, where are you?
Good morning, everyone. Davis Poisson, practice in Wadesboro, North Carolina with Poisson and Bauer with my father and sister. This is my second year on the Ethics Council, second year as a bar counselor for the counties of Anson, Richmond, and Scotland. And I practice primarily personal injury litigation. And I hope everyone's doing well. I'm happy to be here.
Well, thanks, Davis. Welcome back. Mike Ramos from Charlotte.
Morning, Evan. I'm Mike Ramos. I'm the counselor for District 15, which is Bladen, Brunswick, and Columbus counties. It's my 5th year on the council, and I do strictly death penalty defense. Thank you.
Thank you very much, Mike, and welcome back. All right, Warren. Warren is our resident omissions and acts and omissions expert from Raleigh. Warren, where are you?
I'm right here. How are you doing, Evan?
Good.
And everybody? I am one of the counselors, the many counselors from the 10th Judicial District, Wake County. I am a claims attorney at Lawyers Mutual and have been on this ethics committee trying to keep lawyers out of trouble. Or this was I started with Evan, so 7 years.
7 years, right? And it's been great. It's been a great working with you, Warren. Yes, it is.
Right.
All right.
I see that the forces that be recognize the ethical gradations between you and me as you are a new chair. That's congratulations.
Well, Warren, you're not shy about jumping in, so keep it up.
Don't worry.
All right, Counselor 22, John Webster from Albemarle. John, where are you?
Good morning. I'm I think 6th year on the ethics committee. We have a small practice here. We're actually in the throes of starting a new venture with merged firms, so we're neck deep in a bunch of nonsense here. We do a little bit of everything, just general practice in a small county, sort of in the middle of the state. Happy to be back.
Welcome back and look forward to your contributions. Okay, advisory members, looks like we've got a real strong group of new but also returning advisory members. Lamar Armstrong. Lamar, where are you?
Hey there. I'm in my car. Hopefully everybody can hear me.
Yeah, we're good.
Yeah, I'm Lamar Armstrong. I'm from Smithfield, Johnson County. I believe this is my 5th year on the ethics committee. I've sort of lost count. But I got a small town law practice with my family, and including my mother, Marcy, who may be on the call. And we do civil litigation of different types. I do different iterations of that, and I also do appellate work as well on a regular basis. Look forward to another good year with you guys.
Yeah, welcome back, Lamar. All right, Brad Bannon, I mentioned your name in the orientation as one of our expert wordsmiths as we fine tune and polish these formal ethics opinions and rule changes. So welcome back, Brad. Where are you?
I'm right here, and I couldn't agree with you more about your assessment of me. I'm a partner at Patterson Harkavy in Chapel Hill. I represent accused and convicted people in state and federal criminal court. I represent victims of police misconduct and wrongful conviction in state and federal court, and I advise and represent lawyers who are facing ethics questions and allegations of ethical misconduct at the state bar.
Great. Well, welcome back. And if anybody's got any questions, if they can't get through to Brian, Nicole, or Suzanne, Brad is also just a store of institutional knowledge of this committee and the state bar. Sydney Batch from Raleigh. Where are you, Sydney?
Right here. Good morning, everyone. I work in Wake County, and I am a family law attorney. I practice child welfare, and I also do appellate work. And this is my 2nd year on ethics.
Great. Well, welcome. All right, Stacy. Hi, Stacy. Stacy and I know each other well. Stacy Cordis from Charlotte. Where are you?
Right here. Good morning.
There you are. Yep.
Can you hear me?
Yes.
I'm a new appointee to the Ethics Committee. Looking forward to serving. I've practiced in Charlotte in the areas of bankruptcy and debtor creditor work. We also have 2 other lawyers in our firm, Fortis Law, that practice family law. So excited to jump in. Lots to cover, it seems like, after reviewing the packet. So thanks for having me.
Yeah, look forward to working with you and welcome. Tara Gore, I think from Whiteville, is that right?
Yes. Good morning. I'm from Whiteville. That's down in Columbus County in the southeastern corner of the state, District 15. I practice almost completely criminal defense in Bladen, Columbus, and Brunswick counties. And I also practice law with my dad. So I'm very blessed to do that and honored to be a member of this committee. Thank you.
Great. Well, welcome. We look forward to working with you. Elizabeth Willoughby Harrell.
Yes, hi, I'm Liz Harrell.
Okay.
Yes, in Raleigh, and I am actually in-house counsel with HCA, Hospital Corporation of America, that's headquartered in Nashville. I do regulatory work for them. We lived in Nashville for a number of years and then moved back about 4.5 years ago to Raleigh. I'm a Raleigh native, so glad to be back here, and it's my first year as an advisory member.
Great. Well, welcome. We do get some inquiries sometimes dealing with in-house counsel questions. So be prepared to be appointed to those subcommittees.
Yes,
so
sir.
Thanks. Amy Hunt from Charlotte. Welcome back, Amy. Good to see you.
Good morning, Evan. Good morning, everybody. Amy Hunt. I'm in Charlotte. I have completely lost count of how long I've been on this committee, but hearing people give their estimates, it might be too long for me to admit at this point. I do real estate litigation here in Charlotte, and as of just a couple weeks ago, I've moved firms. I'm now with Alexander Ricks, but still doing the same work. So happy to be here.
Great. Well, good new beginnings over there. And one of my favorite people, Jack Lloyd. Jack, good to see you. I always love your contributions. You got a big motor on those shoulders, and so welcome back.
Good morning, everybody. I'm a little bit under the weather here, as you can tell. Sorry about that. Jack Lloyd, I'm in Raleigh. 4 years, I think, Warren. Is that right? 4 years? 5. It has been a great privilege and a great joy to be on this committee. I do consumer advocacy. I'm the supervising attorney of the Consumer Practice Group of Legal Aid. It is my privilege to be able to try cases on behalf of consumers across North Carolina and to mentor and train young attorneys. And that's what I do out of Raleigh. Thank you.
Well, welcome back, Jack. Really look forward to working with you again. All right, Fran Muse from Chapel Hill. Fran, are you on board?
I am. Good morning, everyone. My name is Fran Muse, and I'm honored to have been appointed by Darren to this committee. I can call him Darren because we went to law school together and I've known him a long time. But congratulations, Darren. And again, I'm grateful to be here. I am the director of Carolina Student Legal Services. We are a nonprofit law firm on campus at UNC. I succeeded Dottie Bernholtz. I'm sure many of you know her because she served as our state bar counselor for many years. Prior to joining Carolina Student Legal Services, I was a former public defender in Orange and Chatham County. I was also a solo practitioner for 15 years, serving on many court-appointed lists, both criminal and superior and district court, abuse and neglect cases, guardianship cases, child support. So I've been practicing law for over 30 years, primarily in district court, and happy to be here with all of you.
Yeah, thanks, Fran. You must know my good friend James Williams. He and I practiced at Farm Workers Legal Services, representing migrant farm workers. And I was the one that enticed him to come to Charlotte in the public defender's office. And he and I lived together in my big old farmhouse on 30 acres for about 6 months before he decided to move his family down and take the dive into public defender work. But he's a close friend, and I talk to him frequently. So good to have you on board.
Yeah, James hired me even. I actually work for him, and we keep in touch. So I'll let him know.
Yeah, good. All right, Missy, one of the finest criminal defense attorneys in the state, and also very active in the NACDL on the board of directors. Welcome back. Where are you, Missy?
Right here, Evan. Nice to see you.
And I just want to say I was on the ethics committee for maybe 7 years and then rotated off and did a little stint in AP and grievance. And I'm so excited to be back. This is one of my very favorite volunteer activities I ever get to do. So thank you, Darren.
Well, thank you, Missy, for coming back. Really, your contributions have always been great, helpful, and insightful. Christina Pearsall from Greensboro, I think. Christina, are you on?
Yes, good morning. From Greensboro with Shelbury, and my practice is in commercial real estate transactional. And this is my second year on Ethics Committee. I'm very excited to return.
Thank you. Well, welcome. All right, Stuart Poisson, where are you, Stuart?
Good morning, Evan. Good to see you again.
Hi. Yeah, good to see you.
Hey, I missed you.
Yeah,
Good to see everyone.
I mentioned your name also in orientation as one of the elite wordsmiths as we start working. I mentioned you, Mike Robinson, and Brad. So
wow,
yeah, that's
illustrious company I'm keeping right there. So thank you. But I'm Stuart Poisson. I am pleased to be back on ethics and thank Darren for asking me to join this great group. I'm with Missy. I think I started on ethics in 2014 and then last year rolled over to authorized practice, and I'm very happy to be back. I live down in Wilmington. I practice law with my brother Davis, who's a bar counselor for my home district where I'm originally from, and practiced for a number of years. And then I practiced with my father, Fred, as well. And we do all injury work. I am about 50-50 workers' compensation, personal injury, representing people who've been injured. And I do all the appellate work for our firm as well. I'm very active at the appellate courts, both in our own work and then with amicus work for the North Carolina Advocates for Justice as well. And I'm really pleased to be here. Good to see everybody.
Great. Welcome back. Wasn't your dad also a bar counselor?
My dad was a bar counselor for 9 years, and then my grandfather was a bar counselor for 9 years before that.
So yeah, your family has a deep tradition up here. So
we really enjoy the opportunity to contribute. This is a great opportunity to get to meet friends from across the state and learn and help.
And do important stuff too. It's really important. All right, my friend Bill Powers from Charlotte. He's glad to have him here. He's the former president of the North Carolina Advocates for Justice and has a long history of public service, recipient of a Distinguished Service Award from the State Bar. So Bill, you on? Where are you?
Good morning. Good morning. I'm just a Bill in Charlotte. I see Brian smiling, so I'm sure he'll know what that reference is to. I'm a Schoolhouse Rock generation kid. So I'm just a Bill down in Charlotte. I am really, really honored to be included on this. Thank you so much, Evan and Darren. I see so many faces that I've always known professionally and personally, and I'm honored to be included in this group. I'm an attorney in Charlotte, do criminal defense and DWI primarily. I decided a few years back to make my life a little bit easier and start doing some family law. And I really enjoyed doing that, although admittedly, I prefer the collaborative approach more than anything. So I'm looking forward to learning. I really enjoyed the materials that were sent out, and kudos to Brian. Brian, I wish we had employed more of the orientation perspective on committees when I was with NCAJ. It was really, really well done, well presented materials. So thank you for including me, and I'm honored to be here.
Yeah, even though, Bill, we didn't get through all the slides, there are a couple of them that are really important, especially sort of the flow chart of how this goes. And you can see in one of Brian's flow charts how sometimes the subcommittee goes to ethics committee, back to subcommittee, back to council, maybe back to committee and subcommittee, and it kind of gets into a vortex. But it's all polishing and refining the ethics opinions and the rules. So if we didn't get through all the slides, I encourage you to go back and look at all of them. So All right, Jay Van Oy, famous lawyer from North Wilkesboro. Jay, you on?
Thank you, Evan. Not so famous, but I'm happy to be here.
Oh, yeah, you are. Yeah,
Good
you are.
morning, everybody. I'm Jay Vanoy. I practice at Vanoy, Carver, Triplett, Vanoy. We have an office in North Wilkesboro and in Boone, and I practice pretty much all in the northwestern part of the state. Our office does a little bit of everything. It's a general practice that my dad started a long time ago, and I primarily litigate. Probably 85 or 90% of that's criminal defense, and then I do some civil litigation too. So I'm in the courtroom all the time. I really appreciate Darren asking me to serve. I'm excited. It's my first time participating in with the state bar on any of the committees, so I'm looking forward to the work. And I see a lot of old friends here and a lot of good friends. I look forward to meeting those that I don't know. So thank you, Darren, and I'm honored to be here.
Yeah, well, welcome, Jay. We look forward to your contributions and work. It really is, it's really meaningful, and sometimes there's some real heavy lifting, and sometimes these things drag on for years. And you may hear some references to the AVO committee, which I was on. The AVO committee was something that lasted probably for 2 years and then became moot when AVO shut down their AVO legal services. But we really wrestled with that for quite some time. All right, Catherine, Vice Chair, Catherine Fry from Raleigh. So good morning.
Good morning. I thought I was going to be skipped over. So I was going to appoint Warren to my VC seat, but unfortunately, I'm not going to be able to do that, Warren. So Catherine Fry, I'm from Wake County. This is my 7th year. I spent the last 6 in grievance, with the last year being a vice chair of sub 3. And so currently I am being harassed by all of the grievance people that I have gone over to the ivory tower, and they are asking me if I'm getting any work done at this point. So I'm looking forward to it because it's the other side of the coin. And so I look forward to working with Eben and all of you this year.
We are the forces of good.
Yeah, it's so glad to have you over here, Catherine. Catherine and Warren and Patty Head, one of our public members, have just done some remarkable work on the cybersecurity committee that we're working on. So look forward to it, Catherine. And I'm Eben Rawls. I'm from Charlotte. This is my 7th year on ethics. I practice with 3 other lawyers in Charlotte: Tony Shear, Katie Clary, and Amanda Mingo. We do criminal defense and civil litigation in my small law firm. So I look forward to working with everybody. So did I miss anybody? I do see Alice. Alice, do you want to weigh in? And Tom Anglin raised his hand. Tom, you came in late. I see you there.
Yeah, I came in late. My name's Tom Anglin. I'm in District 2, which is Beaufort, Martin, Washington, Turl, and Hyde. I'm the Chief Assistant District Attorney for that prosecutorial district. I think this is my 3rd year on ethics.
Yeah, great, and welcome back. Thanks for all your contributions. Did I miss anybody else? Did Alice? Do you want to weigh in?
Eben.
Yes, ma'am.
Yeah, can you hear me?
Yeah.
Hi, everybody. I'm on my cell phone. I'm not used to Zooming on my cell phone, so getting used to that technology. But I just was really impressed by the folks on the committee this year. You got a lot of experience and a lot of talent, and I know you all are going to do a great job. So thank you all for your service. And Eben, thank you for chairing the meeting, and have a great meeting.
We will. We'll get some stuff towards the council, I think, by the end of the day. And Lanice is our tireless paralegal, and I see her on. Lanice, do you want to weigh in here?
Yes. Good morning, everyone. My name is Lanice. I am the assistant to the ethics committee, and Brian's assistant, and Alice's assistant, and Peter's assistant. And so if you have any questions about sending anything out, or you need anything, or you need me to hunt down Brian, I'm pretty trained in that. So I'm glad to see all of you here, and I hope we're going to have a good meeting.
Great. Great, great. Thanks, Lenise. And I want to recognize Carmen Bannon too, because she's going to make a presentations later on today. Carmen, you want to weigh in? Because everybody knows Carmen up here. So.
Good morning, everyone. I'm Carmen Bannon. I am working on my 16th year as a deputy counsel in the Office of Counsel. I mostly am a prosecutor, but Brian is my best friend, and it saddened me when he left. So I just tagged along, and I do as much work with the Ethics Committee as time will permit. So I have an excuse to spend time with Brian. So thank you for letting me join.
Great. Kelly DeAngelis, do you want to introduce yourself and weigh in? Kelly, you on? Nope. Jennifer Duncan, who's done some great work. Jennifer, do you want to weigh in? They must be off air. Tom Crosby, I see you on.
Hi, it's Tom Crosby. I'm one of the prosecutors on Office of Counsel. Here to observe, and I'm in my first year in the office, so I'm looking forward to seeing you all work. Appreciate it.
Great, great, and we do have crossover from time to time with with grievance and those questions. Okay, so let's go ahead and start the formal meeting. We're live streaming, right, Brian?
Yes. Yep.
We are. So everybody, just remember that we're live streaming, and what you say is going to be, I guess, permanently recorded. So just remember that. So we always start with our the modern day Bruno Damali, Ann Parkin, who's our auditor, and she's got a report on trust account audits. So Ann, I see you up there, top right. Okay.
Yes.
Good morning, and welcome back.
Good morning. Can everyone hear me okay? I am Ann Parkin. I'm in my 9th year as field auditor, and I travel throughout the state conducting random audits. I'm going to give a brief synopsis of the audit report for the 2021 third and fourth quarter audits. Audits for the third quarter were in District 26 and 38. Both districts were last audited in 2015. Audits for the fourth quarter were in Judicial Districts 18 and 21. District 18 was last audited in 2016. District 21 was last audited in 2017. 27 audits were conducted in District 26. 2 audits were conducted in District 38. 34 audits were conducted in District 18, and 3 audits were conducted in District 21. The 2 most common rule violations for both quarters combined were that 33% failed to identify the client and source of funds on the original deposit slip, and 32% failed to perform quarterly transaction reviews. Audits for the next quarter will be in Judicial District 11, composed of Franklin, Granville, Person, Vance, and Warren counties, and Judicial District 42, composed of Anderson, Polk, and Transylvania counties. Any questions?
Well, it looks like the statistics are trending better than they have in the last year or two for compliance. Is that a fair statement, Ann?
It is. It's a little improvement. And I think consistently the top 2, 3 violations remain the same.
Great, great. Well, as counselors, if you can get this information out to your districts about these problems with the audits, it would be great. We do keep seeing the same mistakes and problems over and over again. So, all right, thank you, Ann. Anybody knows James Burnett or Michael Lovejoy? Those are the 2 bar counselors. They're not on ethics. You might want to mention to them that they're their random audits are coming their way next quarter. So thanks, Ann. Take care.
Thank you. I'm going to leave. Have a good meeting.
Okay, thanks. Be safe.
Thank you.
All right, Suzanne, who's worked with us very closely on a presentation we'll have later on today. She's got a report on ethics phone calls during the prior quarter. Suzanne, thanks.
Hey, normally I give the numbers of the inquiries per quarter, but this time we have a new database. I requested a report for the numbers and I haven't gotten the report back yet. It could come in while we're having this meeting, and if it does, I will pass that number on. But I can report that for 2021, we answered 4,395 inquiries.
Great. Yeah, and that's that is one of the most important programs in the VAR, that and the LAP program and the client assistance fund. All right, thank you, Suzanne. If it comes in, let me know, and we'll publish that information. All right, Brian, you've got a report on CLE ethics presentations during the prior quarter.
Right. You all have in your materials a list of the CLE presentations for the prior quarter by staff. And this is just kind of a little reminder that if anyone in your district needs a CLE, staff is available to offer those CLEs. You know, we'll make our schedules work and be happy to get out there and make those connections with the individuals in your district about the ethics process, or if there's a particular topic that you'd like to cover. I know we can get either as broad in our presentation or as specific in our presentation as the particular audience needs.
Great. Well, thank you, Brian. Any questions from anybody at this point before we move on to the substantive part of the agenda? Great. The first sections have to do with rule amendments, and the first one is a study of and consideration of anti-discrimination language into the rules of professional conduct. So Brian, can you give us a report, a subcommittee report on the status of that and where we are and where we're going?
Absolutely. So the generally speaking, we had a back in, and this is kind of background for some of our new members, but back in mid 2020, we had David Allen, the chair of the ethics committee at that time, initiated essentially a new study of whether or not anti-discrimination language could be adopted into the rules of professional conduct. We started engaging in what has turned out to be a kind of a lengthy study of this issue, including kind of exploring the different constitutional parameters that are associated with this, with including such language in the rules of professional conduct, looking at different jurisdictions to see what other states have done. Notably, the North Carolina is in the vast minority of states in not having any anti-discrimination language in its rules of professional conduct, be it in the text of the rule, which is the majority of states, or even in the comments. So we were looking at this, and of course that got prolonged because we started looking at just the text of the rule, but then also the preamble, and there's an amendment to the preamble, an aspirational statement that has been approved by the council and has been submitted to the Supreme Court. We have not heard back from the Supreme Court at this time, but at this point, the subcommittee still is working on, essentially what rule, if any, could be adopted in the rules of professional conduct that would be constitutionally sound and really kind of appropriate for what we see in the rules of professional conduct being the framework, really the framework for self-governance, reflecting the values of the profession. So that work continues at this point. We were chaired by Steve Robertson, who was rotated off the council, and I believe we're still reaching out to get a new chair, but that subcommittee will continue its work in the next quarter.
All right, it looks like on that subcommittee, we have Mac McCarley and Judge Robert Rader, who are on a grievance, so they're not with us today, but Amy and Judge Hairston Mitchell and Mike Ramos, you guys, let's start with you, Amy Hunt. You got anything to add to that?
No, other than the fact I think we've bitten off a lot and we're still chewing on it, is what I would say.
Okay, so are you making a motion that this go back to subcommittee?
I'll make a motion to keep it in subcommittee.
Okay, all right. Mike Ramos.
I second that.
All
And
right.
I don't know what I got to say about this, but I nominate Dorothy Hairston for chair. I mean,
Second.
It makes sense to me.
Dorothy's plate is pretty full, I think. You know, I think that that Dorothy, I certainly mentioned it to Brian, Dorothy, as you know, and I know how full your plate is. But do you have anything to add to that?
I do not, other than I was going to say the same thing as Amy was saying, was going to make that motion to send it back. And it was an inquiry made to me about being chair. And while I would love to do so, I think that I have to start practicing the art of no, so that I can keep my sanity and be able to really work hard in the areas that I am already working. That does not mean, though, that I won't be on the committee and still work really, really hard at what we're doing. We're doing some good work, and I think that we're on the right path. Great.
Okay, there's a motion and a second. Any discussion from anybody about this going back to subcommittee for the time being? No discussion. Are we going to do a poll, Brian? Is that what we're doing? Okay.
That's right. You all should have a poll that's just popped up, and this is to approve the motion on the floor, which is to send this back to subcommittee.
Oh yeah, I don't vote. That's right. So
yeah, only the members of the ethics committee can vote, and it looks like everybody's the votes are in. That's unanimous.
Great. Okay. Well, this will stay with the subcommittee then, and we'll find a new chair and continue working. Okay. The second rule amendment issue here is the study and consideration of adopting new comment to Rule 1.1 on competency. This also, we asked David Allen to step in as chair of this subcommittee. And thank you, David, for doing that. But I'm going to call on Brian first to kind of give us a report.
Sure. As a part of that initiative in mid-2020 to study anti-discrimination language in the rules of professional conduct, one additional inquiry was to look at Rule 1.1, which deals with competency and whether or not language, particularly in a comment to Rule 1.1, could or should be added regarding a lawyer's awareness of implicit bias and cultural differences that can affect a representation. That subcommittee was initially chaired by Brandy Vickery and was composed of members from both grievance and ethics, as well as some advisory members. And after kind of a bit of education on the topic, then the subcommittee started drafting and ultimately produced a version of a proposed comment that was published and received some negative feedback, some concerns and suggestions to amend the language to clarify exactly what the comment was saying. And the subcommittee re-examined that and revised the proposed comment to the version that you have in your materials today. That version was published over the past quarter. And again, this is the comment to Rule 1.1. You'll see it there if you're looking in your PDF. Use the bookmarks to get to excuse me, what's labeled as IB2. And I'm going to go ahead and put the language on the screen or share my screen so everybody can see what we're talking about. But this is the language here that was published. And again, it says this is a comment to Rule 1.1. that says a lawyer should be aware of implicit bias and cultural differences relative to a client or anyone involved in a client's matter that might affect the lawyer's representation of the client. Such awareness enhances a lawyer's competency and works to ensure understanding of the client's needs, effective communication with the client and others, and adequate representation of the client. So this language, like I said, was published by the Ethics Committee and by the full council after the October meeting, October 2021. During the past quarter, we received one comment. That comment is in your materials. And that comment essentially, you can see it raises some questions about what the terms mean. But these matters, of course, kind of a similar comment to what was received during the prior publication round. But nevertheless, that's at this time before the Ethics Committee after publication. So the thought would be either to send it back to subcommittee for a further discussion in light of the comment, or to recommend adoption by the council. And just as, kind of a part of that continuation of our orientation, if the council adopted this particular proposed amendment to the comment of Rule 1.1, that it would need to go to the Supreme Court for approval as well.
After it goes through council.
That's correct.
Yep. Okay, David Allen, you wanna flesh that out?
Thank you, Mr. Chairman, and thank you, Brian. At Dorothy, you need to practice I'm getting into the art of saying no by going in teeny tiny steps. This will take about, I hope, about 1 second to say. Ed Henson, a former chair of this committee, had a very, you saw his comment. Ed's a thoughtful guy and ruminates a little bit. It really is not a new sort of concern that has been raised here, but something that this subcommittee has dealt with in the past. Subcommittee has chatted about this a little bit, no formal meeting, but just sort of I've tried to get the sense of the subcommittee, and I believe that our recommendation and my motion, Mr. Chairman, would be that the matter be sent to the council for adoption and transmittal to the Supreme Court. That would be our motion.
Okay.
Great. All right. Any discussion on this being sent to council for adoption and then up to the Supreme Court? And I can't see everybody. We got 45 people on here. So if you want to say something, just unmute yourselves and ask to speak. So any hands up? Oh, there's Stacy. Hi,
Yeah.
Stacy. Go ahead.
Now, keep in mind, this is my first foray into this area, but I understand that Ed Henson from Charlotte wrote the comment. Is that correct? And that's what's included in our packet.
That is correct. He actually sent it as an email to Alice, and Gina forwarded that to the rest of our bar counselors so we could see it ahead of time. And but Ed sent it to the wrong email address. He sent it to ncbar.com. And so when I brought it to Brian's attention, Alice called Ed and recovered the email and had it published. So as I understand it, the subcommittee's already looked at that, and it really, this comment seems to be aspirational rather than, and it's not going into the rules. So I think Ed may be a little bit off the mark in my opinion, but Ed is a former chair of this committee and a very thoughtful guy, and he does ruminate a bit, as David said. He preaches some also. So so Stacy, you got a question or a comment?
Well, I agreed with what he said, and I thought that that's true. This comes up a lot in what I do, and I think your point is well taken, that it's just it's an aspiration. As an aspiration, I agree with it. As something that I don't know how you would enforce or ever really in any way make this something that the bar could take an action on, other than we want, obviously, as lawyers, to be aware of our cultural differences and how that relates.
Yeah, and that ultimately is probably going to come up to this committee on the first thing that we sent back to subcommittee, rule amendment that becomes enforceable. But anyway, that's a ways off. I expect that subcommittee will meet for the next year before it actually sort of susses everything out. Then,
Edmund, if I can offer just a quick bit of further background, that was one of the issues that the subcommittee took up when it revised the comment, because I think the comment as originally published caused some confusion as to whether or not this was truly aspirational, and that's where they added the language of how a lawyer should be aware. Because of course, shoulds can't be enforced in our rules, not to mention that it is in the comment as well. But they wanted to make it very clear that this was an aspirational statement. And we had some input from the Office of Counsel as to whether or not there was any feeling that this could be enforced. And I think it was very clear that this is not something to enforce. This is, like we said, an aspirational statement.
Okay.
See, Andrea has her hand up.
That's helpful. Thank you.
Yes. Hey, Andrea.
Hang on.
Can you hear me? I think I'm
Yes.
on. Okay.
I'm
So
looking for you. I can't see you yet, but I'm go
around.
ahead. Oh yeah, there you are.
Well, this is actually obviously my first experience with dealing with these rules. I just wanted to make a comment. I've always been very supportive of becoming aware, or having attorneys aspire to become aware of implicit bias. It was very helpful to me to read Ed's comments, because it made me question some of, I mean, I thought that the points were well taken, and it made me question my own personal experiences with implicit bias. I realize it's late in the game, and I hear you that the committee has vetted this, and I trust the committee's decision. And I think if I had to make any comment, again, it may be too late, but if there was any way to use the word aspirational in that comment, then I think it would just add to the intent of what that comment is supposed to be. I know that you said that there's the word should, but I think it's really helpful to make that distinction clear. So that's all I had to say.
Great. Well, thank you very much. Anybody else? Like I say, I'm seeing postage stamp pictures of everybody. Now,
See, Stuart has her hand raised.
Evan, this is Stuart. Yeah, I just had a comment.
Stuart.
Hey, I've been on this subcommittee that looked at this issue, and all of the comments that are being raised today are excellent and are things that we all discussed. When we looked at the issue of putting aspirational in there, all kinds of language like that. And what we did was we looked at the comments in context. And if you look at the definition of comment, I can't remember where it is, Brian, but I'm sure you can tell us. It says in that definition that these are aspirational. And so that's the reason we didn't specifically include it in this particular subclause, because it's not included in all of the other comments to the rule. And we did model, after receiving a lot of comments from the public when it was published, we did model this language after the language that was used in the comment that we added a few years ago about the technology requirement for competence. And so this language pretty directly tracks that. And just from a personal perspective, I think the fact that we only got one comment on this compared to all of the comments we got in the past shows that we're really on the right track with this. So I just provide that for historical context, because I know a lot of folks are new to the committee, but we did definitely look at all of that.
Great, thanks, Stuart. Brian, you want to add anything to that?
No, I think Stuart summed it up very well.
All right, David, do you want to add anything else after all that?
No, I do. I mean, all that background is helpful, and Stuart's right. This subcommittee has received previously over its life, which is now, I don't know, Stuart, 18 months, has received, tons and tons of comments along that. I saw Tom Langen's comment about it. This is really to raise the consciousness of us of implicit bias, and try to understand that and try to avoid that. You're right, and there's no enforcement mechanism here. This would be impossible to avoid, enforce. It's to say what you should avoid conflicts of interest. You should avoid things that bring the profession into disrepute. It is you should do these things, and by being aware of them, you're better able to avoid them. I think that's the goal of this conduct.
Yeah, I agree. All right. Anybody else? Todd Brown, how does this fit in with your issues committee group, diversity, equity, and inclusion? You're usually not shy about weighing in. What do you think?
I think the comment language is spot on. I have no problems with it, and I support it.
Great, thank you very much. All right, anybody else? Then I guess we got a motion and a second, so let's vote on it. This, if it passes, it will go to the full council for adoption.
Yeah, and just procedurally, it will go to executive first.
Oh, yeah,
this
executive
afternoon,
first,
and then to the full council.
Yep, thank you, Brian.
If I need to amend my motion to do that, please consider it amended, Mr. Council.
Yeah. I think your motion is still appropriate.
All right, looks like we got 25 for, 2 against, so it passes.
26 to 2.
26 to 2, okay. Yeah, 27 to 2.
Yes.
There's people are still weighing in, so.
All right. I think I'm gonna go ahead and end the poll now. Thank you, everyone.
All right. I think that's it. Brian, you want me to close this out, or you want to?
Yeah, no, I think we'll just go ahead and send this on its way, and we will. I think we can move on to the next item.
All righty. Okay. We shared those results. Okay. Now it's Carmen's turn. The next one is a study and consideration of Rule 1.19 of the Rules of Professional Conduct, which involves sexual relations with clients. I'm always amazed at how some lawyers can get right up to the line on some of this, and so this has been looked at and kicked around. And Carmen, you want to set the table for us?
Yes, sir. I will say that compared to other jurisdictions, North Carolina already has a good and workable rule prohibiting sex with clients, but it can still be improved. And there, just for the benefit of new members, there were 2 inspirations, I believe, for creating this subcommittee. One was in another ethics subcommittee. Brian and I were doing an exercise of presenting fact patterns to the subcommittee and essentially just asking the committee members, do you think this should be allowed under the ethics rules? And one fact pattern that was pulled from another state was a situation in which a lawyer was offering discounts on legal fees in exchange for the client sending nude photographs to the lawyer. There was no sexual contact, but that was the business arrangement proposed by the lawyer, and this subcommittee unanimously agreed that that should not be allowed under our rules. Under the existing version of Rule 1.19, that kind of conduct is not covered. The rule speaks specifically to sexual relations, sexual touching, that kind of thing. Another inspiration, at least for me, is what I've actually seen in the disciplinary process. Maybe because it's hard to make me blush, my prosecutorial niche seems to be these kinds of boundary violation cases. And I've looked at a lot of messages that I can't unsee. And the challenge in prosecuting that is that in order to establish a rule violation, I have to prove that the sending or requesting of the messages was an attempt to have sex with the client. So that's an additional layer of getting into the state of mind that is challenging. So the original impetus for the subcommittee was primarily to consider adding a clause that would prohibit a lawyer from either sending or requesting explicit material from a client, of course, provided anything that was actually relevant to the case would not fall under this rule. We're looking at that. I think we've made progress in incorporating that into a proposed modification to the rule. But then, of course, we've also started tinkering with some other pieces, and the details of that are in the subcommittee minutes in your materials. So I think we're still in that process of refining, and I have made some really good progress towards making our rule even better.
Well, thanks for your work. Now,
Mr. Chairman.
Yes, let me get Dorothy first, if you don't mind, Warren. Is that okay?
All I wanted to say was I wanted to compliment Carmen on her minutes. After having read the minutes, I had to see who wrote them, and I realized it was Carmen, and I was not surprised. I thought they were quite amusing and entertaining. Thank you very much.
Thanks, Warren.
Yeah, if Carmen can find kind of an amusing angle from time to time, she can find it. So it's great. All right, Dorothy, you're chairing this committee. What, you
I
got
am.
anything to add?
Well, just a little bit. I will say echo that Carmen has been phenomenal, as well as Brian and his help with her on this subcommittee. I always like to give kudos to our staff because they do the heavy lifting, as I always say. I think that our subcommittee has done a really, really good job of really honing into what is this type of communication. I think a lot of us came onto this subcommittee thinking you would know it when you see it. And we have learned from Carmen and Brian that is not always the case. That people have varying ideas as to what is sexually explicit, what is communication, the different forms of communication, and all of that good stuff. So we have really narrowed it down and tried to be really detailed and clear as to what is explicit, what the types of communication are, and all of that good stuff. And so we are still working through that. And so I would like for us to be able to continue to do that so that we can really get this tailored in a way for Carmen to really do the work that she is doing and doing well, and not have to see that additional layer of trying to have sexual relate, because as you did, even you noted that this was about sexual relations, and this really isn't. I mean, it involves some sexual relations maybe, but is not always something that leads to requests for that. It could just simply be sending some sexually explicit or requesting them and different things like that. So I would like for us to be able to continue to work on this and get it in a place that will be good moving forward.
Yes, I guess it's a penumbral sexual relations. But Dorothy, I'll take that as a motion to send it back to subcommittee.
That is my motion.
All right. Is there a second?
A second.
All right, thanks, Takia. Any discussion? Warren, you want to weigh in on anything on this?
No, thank you.
Okay.
I did note that Mac only gets frustrated with the ethics committee when we start discussing these topics, which is, if I recall, that was the last time that we got too in the weeds for him on what is sex.
I think he used the word loathsome because of the granularity of the ethics committee. So that's some pretty strong language. So, all right, discussion on this topic. And once again, unmute yourself if you want to say something, because I can't see hands on postage stamp stuff.
Evan, this is Gina. Can you hear me?
Yes, Gina, thanks.
As you could tell from Carmen's minutes, I am the ironic sort of naysayer in this. I'm just concerned that we're getting a little bit out of our lane. I think our lane needs to be sexual communication that is exploiting a client in some kind of way. And I think we're getting a little noble, and we're trying to regulate conduct that we think is distasteful or unseemly, but not necessarily exploitive. So that's my only comment. Unfortunately, the only way I can articulate it is to talk about bro culture, and me being the champion of bro culture is ironic for those of you who know me. But in any event, we're walking that line, and that's why it's taken us a minute.
All right. Well, thank you, Gina. Yeah, I don't know if this is just simply 1.19 or could spill over to 4.4, I think. Okay, any other comments? I don't see anybody. So the motion is to send this back to subcommittee. Let's vote on that.
That's unanimous.
Great. Great. All right, this goes back to subcommittee. All right, subcommittee reports. We're going to skip over number one. I'm the chair of that subcommittee, and so Catherine Fry will take over as chair when we talk about that. So we're going to skip down to number two with lawyer possession of contraband during representation. And this has been an interesting one also. And Nicole, can you lay it out for everybody on this one? Thank you so much.
Sure, I'd be happy to. So this is, I'm going to give a little bit more information about this opinion than we normally do. It's been through several drafts and we've talked about it for a long time, but for the benefit of our new members of the committee, this inquiry originally came from the grievance committee, and the opinion addresses a lawyer's professional responsibility when the lawyer comes into possession of a photograph portraying a minor child engaged in sexual activity. As you can see in the materials, the facts of this matter is that a lawyer represents a mom in a custody action. The mom finds this picture of her daughter engaged in sexual activity on the daughter's phone, presents it to the lawyer and says, I want you to use this in this custody action against the dad because this happened while she was with the dad. The opinion has been through several drafts, but it ultimately concludes that illicit images of children engaged in sexual activity is considered contraband. There are laws, both state and federal, that prohibit the possession of contraband, including for lawyers. There is no exception in the statutes for lawyers to be able to possess contraband when they're acting in a representative capacity. The opinion also states that the lawyer must review the law to determine if the lawyer and/or the client have a duty to report the existence of the photographs to law enforcement or to Department of Social Services. That was an issue that the subcommittee talked about extensively. In the beginning, the first draft of the opinion did not mention any report to law enforcement, but the subcommittee ultimately decided that under the law, that's the right thing to do. The opinion was published for comment after the October 2021 meeting, and we received only one comment from Michael Adkins. He was concerned that the opinion really doesn't give lawyers any clear guidance on what to do with the photo. He pointed out that the clients can't possess the photograph because it's illegal. Lawyers can't possess the photograph because it is illegal. That includes the DA and defense counsel, and just felt that the opinion needs to give more guidance on what can lawyers do with under these circumstances. He also pointed out that the only thing the lawyer could do is notify law enforcement and then hope for the best. So the subcommittee reviewed these comments and decided that Mr. Atkins is incorrect. Law enforcement is allowed to possess contraband, and these pictures of a minor child engaged in sexual activity is no different than any other contraband like firearms or, sorry, not firearms, drugs. Because law enforcement can possess it, we have several subcommittee members who do a lot of criminal work, both on the defense and the prosecutor side, who say that at both state and federal court, the lawyers will sit down with law enforcement to review the photographs. So that is a way that lawyers do have the ability to use the photograph while not possessing the photograph. So the subcommittee unanimously voted that no changes were necessary to the opinion, and the opinion is correct as written.
Thanks, Nicole. I think that's a very good and thorough presentation. And we do have some prosecutors and some defense attorneys on this subcommittee. So Takia, I think you're chair of the subcommittee, is that right?
Yes, that's right, I am. I want to thank Nicole. We've gone back and forth several times on this opinion. And I know probably for some of the new members of the committee, it seems like it's not giving as much as it could or it should, but trust me, we went back and forth several times on whether we should expand it, what we should add, if there was anything we needed to take away. There were several different drafts of this, and I think just based on the subject matter, it is better to be more direct and specific with this question, because once you start trying to add to it, you end up changing the question and changing what is actually being asked and what you're actually looking at. So I think for this this opinion, that this is the the best, that we could come up with, because we did put a lot of thought and a lot of work into it. And I think that we all at this point agree to it and think that this is, the product that we should present to the council. And I like I said, I think that's what everybody is agreeing to at this point. So I think it's my motion to send it to the council since it's been published. Is that correct? Is that right? Okay.
Yeah, motion for adoption. Yes. And it'll go through the executive committee, then to council. So is there a second?
Seconded.
Great. Thank you, Tom. Tom, from the prosecutor's perspective, you want to add to some of this? Because this has got some really difficult issues that are buried under the surface here.
It does, and I think you could probably spend a lot more time dealing with some of those other issues, but I think the assumption we made was that it was in fact contraband. There was no debate about that. And once it is determined to be some contraband of a sexual act, what are your responsibilities? And I think we tried to keep it simple in that respect and direct, like Takia said, and I think she did a good job shepherding this through the subcommittee.
Yes, and I do criminal defense, and I know that I don't like doing it, but I go out to the FBI and they have the stuff and they show it. And I usually ask my clients on the criminal side if we ask for written descriptions first, and we go over that, and then I ask them to agree that those are correct, rather than having to go through the toxicity of having to go through all those files. The other question that comes up, and I guess you guys dealt with this, is what if a lawyer inadvertently receives a picture like this? A lawyer can't destroy it. It's destruction of evidence. I mean, do we have enough guidance on that issue in there? Or do we need to?
That was one of the things that we looked at too. That was a part of the opinion at one point. I think in these situations, to go case-based. The things that would probably change because that was being asked to be in. So that's why we tailored it the way that we did. And then it's just better to just, seek out advice on that specific or other specific variations, if you will, of this issue.
Yeah, that's correct. So the committee did talk about that. And that was that question was not part of the original inquiry. And so the committee decided we need to answer the questions that are asked, and that it would be difficult to anticipate every type of scenario and address that in an ethics opinion.
Great. And I agree with that, because the same issue came up on this confidentiality of information. We addressed the narrow question presented under Rule 1.6. But yeah, great. And I concur with that. Anybody else want to weigh in on this issue? There's a motion to adopt and a second. I don't see anybody. Anybody want to say anything? Let's take a vote.
It looks like voting has slowed down. We have 25-1 in favor of the motion.
27-1 now.
27-1. All right.
All right. Okay. All right. We'll move to the next issue, which is an interesting one also. This is the local service advertising by Google. The pay per lead program, and it touches on a few of the rules of professional conduct. I will say we got some really good comments. I did review those. And so Suzanne, can you set this up, please?
Sure. And this is a good example of how the ethics process actually works, because This inquiry has gone through a lot of the different stages that for the new members was discussed at the orientation. We first received this inquiry in October 2020, and as Evan said, it deals with a Google advertising program that uses local service ads. So the purpose of the program is to connect potential legal clients with lawyers that are in their geographic area.
Something related. Do you want to know how do local services ads work?
Oh, somebody asked Siri about local service ads. That's funny. Anyway, so if a lawyer purchases a local service ad, the way this works is if a potential client puts in the search family lawyer near me, then a lawyer who has purchased a local service ad, their Google ad will appear at the top of the search results. The ad will just contain basic information about the lawyer, and it will also contain a contact phone number. But the phone number that is on the local service ad is not the lawyer's personal phone number. It is actually a number that has been assigned to the lawyer by Google. When the potential client calls that number, the telephone call is routed through the Google website before the call is connected to the law firm. And as part of the routing process, the communication is recorded and retained by Google for a period of time. And it is the recording and the retention of the communications that was the concern for the Ethics Committee. There was just a general feeling that that had to be a violation somehow of the duty of confidentiality that lawyers owe to the clients. So the inquiry was first sent to subcommittee after the October 2020 meeting. Subcommittee met several times on this. One of the issues that we really struggled with was whether the individual making the initial phone call was a prospective client or not. If that individual was a prospective client under Rule 1.118, then they would be entitled to certain duties of confidentiality. We studied Rule 1.18 and the comments, particularly comment number 4, and concluded that at the time that individual makes the first phone call, they are not yet a prospective client. Comment 4 to the rule says that someone is not a prospective client when they simply respond to an ad that only contains a lawyer's basic information. So we did not want to say in the opinion that this was a prospective client, because then we might be saying anybody that responded to an ad in the yellow pages, as if they still existed, would be a prospective client, and that is not what the rule intended. But the subcommittee was still bothered by the fact, by the way the advertising program was set up and by the fact that the calls were recorded and retained by Google. Ultimately, the subcommittee drafted an opinion relying on Rule 8.4 and concluded that the structure of the program is prejudicial to the administration of justice. The reason for that is because it makes confidential information vulnerable. It's possible that these phone calls could be requested by subpoena at some point, and the program is structured in such a way that it does not comply with the expectations of individuals seeking justice through communication with a lawyer, the expectations of privacy and exclusivity. So after the July 2021 meeting, that proposed opinion was published for comment. As Evan noted, we got a lot of comments opposed to the proposed opinion. I'll just go through a few of them. Some of the comments suggested the opinion was in the restraint of trade. Some affect access to justice. Other advertising programs use landing pages and tracking phone numbers like this. The types of phone calls that would be recorded would just be initial phone calls, appointment setting type phone calls. So there wouldn't really be any important confidential information obtained. But 2 comments specifically concerned the subcommittee the most. One comment was that the policy of recording and retaining the information that is in this advertising program is the same or similar to what's included in all of Google's products. So for instance, Gmail, Google Home, anything that any product you're using that's going through Google has this similar type of policy. And there was a fear that this opinion would potentially prohibit lawyers from using products and services that they're already using because they're Google products. The other comment that concerned the subcommittee was comments that stated that the ethics committee has already approved the use of services where there's even more information obtained, and specifically referenced the ethics opinion that talked about the use of cloud services. So that's already been approved. The subcommittee members also just discussed the fact that there's no evidence that the general public has been harmed by this advertising program so far. So after reviewing all the comments, the subcommittee came to the conclusion that this proposed opinion perhaps went too far in the effort to protect the general public. As I stated, this individual is not even a prospective client. It's not a client, it's not a prospective client, it's just a member of the public. Perhaps the ethics committee was trying too hard to protect the general public, and that there was possibly some unintended consequences of this opinion if it remained as it was written. The subcommittee decided that they would recommend that the opinion not be adopted. But because the proposed opinion was already published and was already out there, they would like to publish something to inform lawyers that the opinion was not adopted, and to maybe give some of the reasoning of why they took it as an inquiry to begin with, and then why they decided not to publish a formal opinion. So one of the things that we talked about was perhaps a journal article that would talk about this inquiry specifically, and then also maybe remind lawyers of the general duties that they have when they're considering entering into any type of advertising program. And the chair has left the chair.
Well then.
Vice Chair.
I was going to say, I think at this point, if I don't want to speak for Evan, but I do think this might be a good time to kick this over to Gina for some thoughts.
Okay, no problem. Well, obviously Suzanne's right about all that, and that's where we are right now, is that she is in the process of drafting such an article. We are sending her feedback on the article. It is my understanding that we should not deem this a failure, that we should decide that some issues are so evolutionary and revolutionary and fast moving that we can't really we can't really address them with ethics opinions, because by the time we publish the ethics opinion, it's moot, it's inapplicable, the technology's changed, whatever. So maybe an article advising people about all of the traps for the unwary is the way to go. It's a great article already, but it's still in the drafting process. So I move that we leave it in subcommittee so we can continue working on this article.
Is there a second to that?
I'll second.
Okay. All right. Discussion. This is interesting. It really is. And there's several different ways we can go with this. So I look forward to seeing y'all's recommendation. Any discussion on this at this point about whether an article might be the best way to address this issue? All right. We'll go back. Let's vote. Wait a minute, Bert, you got something. Let's hold the vote.
No, as a member of the Publications Committee, anyone on that this subcommittee who wants to write an article, we will gladly take it.
Got it.
Because we're looking for good material from good people.
I have a question.
All right.
Just a clarification. My understanding was, based upon the report of Suzanne, was that we are basically voting to stop the inquiry at this point in time. I'm not sure what the legal words should be used.
Sure. So Tom, I'll clarify. I think at this time the motion is sent back to subcommittee, but I think the kind of the forecast is that the subcommittee, in looking at this article, if there's an article that we can produce, it's probably going to be a recommendation to withdraw the inquiry. Okay. And not issue an opinion, but instead go with the article. And for whatever it's worth, I wanted to be clear, this is not terribly unprecedented. I think this is something where we need to offer some guidance to the bar on this type of thing. But I think we've also run into this in other technology situations before, where we may draft an opinion over the course of 6 months, only to find that the business that's running the technology has changed in light of our concerns. And suddenly we would have a permanent opinion that essentially says lawyers can't use this service that no longer exists. And that's not very helpful. If anything, it just causes more confusion.
Yeah, I mean, I agree with it. I just, so it really, what we're talking about is sending it back to subcommittee, and then the subcommittee will make a report commensurate or include the article to be submitted for publication to formally close the matter at that point in time. I understand that. Thank you very much.
Andrea, you got your hand up.
I did. One of the things I'm learning by sitting here listening to everybody is that when it's been in subcommittee, it's been vetted to the point that any thoughts I have probably already been addressed. So I guess this would be my question to Gina or Suzanne. For my benefit and the benefit of those who are just jumping in today, I think I read this, but can you confirm that there is when a client or potential client is getting ready to make the call or is on the call, that there is something that advises them that they are being recorded? That was one.
Yes, that's
okay.
correct. There's the typical message: this call is being recorded. It's not confidential. But the concern that the subcommittee had was that even with that message, it didn't go into detail about why the fact that it's not confidential might be important.
Okay. I mean, that makes me feel more comfortable, at least being able to say, well, you were advised about that. And that just leads me to a second comment that ties into this. Or thought, so to speak, and that is that we domestic attorneys especially know that even potential clients will just give you a lot more information than scheduling a phone call. You can't even interrupt them and stop them before they do. And I know, and I trust that that's been vetted too. So I'm not asking for any more consideration. Those were just the things that came to mind that would have been concerning to me if I was in here discussing it early on.
Yeah, and Andrea, I'll add one of the things, because that was one of the things that the subcommittee discussed, and I participated in the subcommittee as well, because this is a really puzzling issue, and we've gotten a lot of calls, and frankly, a lot of passionate calls, either for or against using the service. And that issue of people just starting to run their mouth is a very real thing, particularly when you're talking about family issues or even criminal defense issues, which it could be really, really crucial. But the thing that was brought up by one of the comments that really made me kind of look at this differently is, if somebody puts all that into an email and sends it through their Gmail or to your account that's hosted by Google, whether you realize it or not, those emails are being reviewed by some type of internal process at Google, not necessarily to see the substance of it, but there's a lot of that review for advertising purposes and those algorithms and all that kind of stuff. And so the ripple effect of this opinion, how that could potentially make you have to start looking at your internet service provider. If you're sending an email over your Verizon phone, for example, what sort of review is going on by all these different internet service providers, suddenly it gets expansive and could potentially bring all communications to a crippling halt because someone else is reviewing it for other purposes. And I think that's the sort of thing, of course, when you send an email, you don't have that sort of warning. And that was the thing that I think I saw the subcommittee struggling with. I personally struggled with that and saw that was a lot of one of the big comments that we received, just kind of pointing out how similar this is. Different medium, different format of communicating, but very similar program to what we have been using for a long time. And this type of opinion could really impact our ability to effectively communicate with clients. So yeah, it's been vetted. It's tough.
Yeah, and I think that's why, because of the fact that you're saying there was so much opinions on both sides, I think this article is a great idea. And I think bringing those points up hopefully will alleviate the concerns of those that were favorable to this rule. So, yeah.
All right. Hey, Jack Lloyd, you had your hand up more, and then I'll call on you.
Yeah, I was just going to add real quick. Brian probably covered this in the orientation piece, but it was very helpful to me when I first joined the committee to learn that there was kind of a tiered set of options that we have as a committee to respond to questions, that everything doesn't have to be some full-blown FEO. And so I just wanted to point that out. And I didn't know, Brian, if you had addressed that during their orientation, but for the new members to know that there are ways that we can answer questions and deal with queries that doesn't always have to turn into unpublished issue. And that thinking through that as an opportunity, I think has in the past alleviated our need to go into multiple subcommittees multiple times. But I just share that for new members.
Thank you, Jack. Warren, you want to say something?
I think the subcommittee also was thinking that this article could be yet another reminder to lawyers to educate their staff on, you don't pick up the phone for an unsolicited call and say, tell me your whole story and I'll take it. You don't do that. So you have basically a way to train your staff for this call and any unsolicited call or email that you need to, if you don't want to make them a prospective client, then you need to make sure you don't do that. So.
Yeah, to me, this is another example of where technology rapidly outpaces traditional professional work. And this is not going to be the last time we see something like this. We've seen it before with some things, and especially where there's money involved. So we'll see it again.
And to Google's credit, they're not just monitoring this in order to try to monetize it and make more money off of advertising. They do it also to sort of to keep track of spam calls and scammers and things like that as part of that whole process too. Robocalls. So, I mean, there's legitimate reason for monitoring, same as they do with your email.
Yeah, and it sounds like they vet the lawyers too, at least, superficially. So, okay, we've got a motion to send this back to subcommittee in a second. Any more discussion on this from anybody? If there is, just holler out.
This is Stacy. I was just gonna echo Andrea's and some other comments about the article. I think that's really helpful. I think some of us, when we started, there was basically no advertising 30, plus years ago. And it's amazing where we are now, but I think that's really helpful where some attorneys won't bother to read the proposal and the opinions, the comments. An article is really helpful. So like that idea.
Okay, thanks, Stacy. Anybody else? All right, let's put a poll up, Brian. Back to subcommittee.
All right, that appears to be unanimous.
Great. Okay, well, it goes back to subcommittee. All right, the next is the attorney serving in the dual role of guardian ad litem and advocate. And at some point, if we've been at this now an hour and 45 minutes, does anybody feel like they need to take a break, get some more coffee? Yes, is that Catherine saying yes? All right, let's take a 5-minute break and come back. and everybody get some coffee and be ready to talk about dual role of guardian ad litem and advocate. Thanks.
That sounds good.
Excellent job, Mr. Chairman.
Are you enjoying yourself, Bill?
I am. I really, I thought Brian's presentation, I'm just kind of kicking myself with some prior meetings we had done. It would have been so helpful to kind of set forth that, like, the procedure. He took a complicated subject and made it simple sounding, and that's really a skill. And his presentation on PowerPoint was spot on as far as the aesthetic. That's harder to do than a lot of people realize. He had very, very clear information that didn't take away from what he was saying, but also it was very easy to read. The color palette was good. He did a really, really good job. So,
yeah, he sure did. And there, the one he didn't get to that one page that shows the flow chart, which is really helpful, I think. I talked to Brian yesterday, and we both agreed it would be impossible to get through all this in 25 minutes. So
yeah. So it was, yeah, I'm really interesting. The topic's interesting to me too. So
yeah,
looks like we're still streaming too. I'm sorry, go ahead.
Yeah, after this week, I'll give you a call about that other thing we're talking about. Okay.
Yes, sir.
Everybody be quiet. He's back in the room.
What'd I miss?
All of the unethical talk, Brian.
All right. Well, we were streaming the whole time. I didn't want to. Exactly. I didn't want to ruin everything.
No, you were being complimented on your PowerPoint slideshow.
Oh, well, thank you.
Yeah.
Are we talking about the orientation?
Yes.
Okay, yeah, well, I appreciate that. Yeah, I realized after we talked to Evan yesterday, when I went back and looked at January of 2021, we had an hour for the orientation in January, as opposed to 25 minutes. So that's probably why there were more slides.
That hour would have been 25 minutes for you and 35 for David Allen.
Right.
Here, there's no question. That's why we had to do it that way. Mr. Chairman, just one point of personal privilege. If we all saw Catherine Fry yesterday, she was in the UK. Yeah. So that has inspired me to get my coffee out of the Tower of London cup. So Catherine, right. Here's to you.
So I'm still in the UK. I am on the backside of Buckingham Palace.
So she's on the Queen side with a public front. She's been admitted to the backyard where the tea is being served, I'm sure.
That's right. I am all into the British monarchy and gossip of late. So I am here at the Queen's bidding, helping. How's that?
They need a spin doctor.
They have a little bit of drama there, just a wee bit.
Evan, it looks like everyone's back. Do you want to get back on the agenda?
I don't see pictures. So yeah, we'll get started on this. So the next inquiry is the one about an attorney serving as a dual role of guardian ad litem and an advocate in the same case, same person. And this of course touches on Rule 3.7 conflict of interest and also some of the statutory references in Chapter 7B. So Nicole, you've done a great job with this. Let's set it out.
This is the inquiry of O'Rourke that we received.
Yes, ma'am, it is.
Asking whether or not a lawyer can serve a dual role of attorney advocate and guardian ad litem in abuse, neglect, and dependency cases. Historically, one lawyer has been appointed to serve dual roles. And after this inquiry, we realized that a lot of lawyers and judges don't understand or did not know that a lawyer serving a dual role in this capacity would raise a conflict for the lawyer under Rule 3.7. Rule 3.7 is the lawyer as a witness rule that says that a lawyer may not serve as an advocate and simultaneously serve as a necessary witness in a client's trial. The opinion has been through several drafts, but it boils down to this, that the proposed opinion states that if an attorney is appointed as the dual role, I'm sorry, let me back up and say that the problem that is raised by Rule 3.7 is that as an advocate, of course, you understand that the lawyer has a duty to represent the client's legal interest. But as the guardian ad litem role, the lawyer has to prepare a court report, file that report with the court, and then testify as to the contents of that report. So that's where the lawyer becomes a necessary witness in his guardian or her guardian ad litem role. So the proposed opinion states that if an attorney is appointed to serve the dual role, the attorney must immediately inform the court of Rule 3.7 and the conflict created by that, seek the court's clarification on what the lawyer's role is, ask the court to appoint the lawyer to just one role, either as the advocate or the guardian ad litem, and then ask the court to reduce the court's decision to a formal written order. The opinion goes on to say that the lawyer may only serve as both roles, the dual role of guardian ad litem and attorney advocate, if the court orders the lawyer to do so. So this is after the court has heard from the lawyer about the conflicts raised by Rule 3.7. The opinion recognizes the court's concurrent jurisdiction on matters of ethics with the state bar. So the court can hear the evidence or hear testimony from the lawyer as to why 3.7 causes a problem for the lawyer. But the court can decide that for purposes of judicial efficiency or for whatever the reason is, that the lawyer may serve the dual role. So the Ethics Committee did talk about the fact that because historically only one lawyer is appointed, that in some districts it would be difficult, if not impossible, to appoint two separate lawyers to serve in these dual roles, and that for judicial efficiency, the court may need to appoint one lawyer to serve in both roles. So a lot of the language that was initially put into the proposed opinion about the lawyer just simply cannot do this under any circumstances was removed. So at our, we had a subcommittee meeting back in November. The committee directed me to make some minor changes to the opinion, and you can see that in your materials, the track changes of that changes that were made to the opinion. I think at this point, the committee has had enough sufficient discussion and hopefully is satisfied with the opinion as it is written. I think it's ready to publish, but I will defer to my subcommittee in case anybody feels differently.
Thanks, Nicole. Dion, aren't you chairing this subcommittee?
Yes, I am. And first of all, I just want to thank Nicole for taking us full circle almost. She did a lot of work on some things that we ultimately pulled out from the opinion, but it was because of the great debates that we had, John, Gina, Sydney, Jack, and Dorothy, that we, I think, landed on an opinion that I'm really proud of. One of the things as an attorney, I think that just down boots on the ground that we have problems with is when we're trying to fit that ivory tower into a rural courtroom that has always done things a certain way, with a judge telling you that you're going to do things a certain way. And what I like about the way that this opinion has shaped up is it gives really good step-by-step advice of what an attorney should do when she's faced with that. By, first of all, identifying the Rule 3.7 problem to the judge to make sure he or she is aware of it. And then secondly, by asking the judge on the record and in a written order to clarify the role, again, asking for it to be one or the other. And then third, letting us know that the judge simply doesn't do that, that we're okay because this rule or this opinion, the way that it's written, would provide that that judge in concurrent jurisdiction to be able to give the pathway to that dual representation. So I'm happy with it, and I don't know if the other subcommittee members would like to comment, but at some point I'm ready to make a motion to publish.
Yeah, let me ask you this, Dion. It looks like there's a current track changes version that's in the agenda. Do you want to, do you want to send it back to subcommittee to really polish it up, or do you want to go ahead and make a motion to publish with the changes already tracked?
I think my motion would be to accept the changes to make it pretty and no longer red line, but then to publish that.
Okay, that's a motion. Is there a second to that motion?
Second. This is Dorothy.
Okay, great, Dorothy. All right, let's have some discussion. Gina, where are you? Hey.
I'm here. I don't have anything to add to it, although there are lots of questions in the chat that I think we probably need to answer so that people understand what this circumstance is. First question was, doesn't the GAL attorney rely on the GAL volunteers to prepare reports? No, it seems that it's different practice in every single county. Most of the time we think it's lawyers doing it, but a lot of times in smaller counties, there aren't two people available for these roles. Let's see. Yes, Bill Powers, there was conversation regarding best interest counsel. The guardian ad litem issue comes up in juvenile court, which is what we're primarily interested in here. It also comes up in contested custody cases in family court or district court. And what Bill's referring to is there's Nicole will have to tell us the state bar opinion that deals with the differences between being a consultant, being a best interest lawyer, and being a old school guardian ad litem. But anyway, the point is this, that in order to address all of these varying degrees of uses of the guardian ad litem and abuses of the lawyers who are serving in these roles, this is what we've come up with to try to cover as much ground as we can.
Okay, thank you, Gina. John Webster, you want to say something? John, you there? Let's see. How about Sydney? Sydney, are you? I see you, Sydney. You're here. You want to weigh in on this?
I just answered the questions in the chat, and at the end of the day, I think that Dorothy and I, who prior to her being appointed to the bench, which we're very happy, working in that courtroom a lot, have noticed, and it is a common practice that there's one attorney that's representing both parties, and we feel like that was problematic. And so I think that the way that we finally settle on it in the subcommittee is a good balance with regards to allowing the judge to give some of us who serve in both roles the capacity, basically the cover to say, okay, we're not violating the rules of professional conduct. Right. There are some counties like Wake who have started to appoint both an attorney to be the volunteer and an attorney to represent the attorney. But other counties have not done that to date. And so it'll just be up to judges. And I think that this is a really good balance of making sure that attorneys have cover, but that hopefully people will actually do the right thing. And what I at least contend is having two different people serve that role. So there's no longer the conflict of the witness and also the attorney advocate.
Great, thank you. Jack, you're on board too, aren't you?
I am, and I just want to thank Dion for the way that she ran these meetings. We spent a lot of hours on this. This is kind of one of these quintessential ethics committee subcommittee matters where you really are getting down to where the rubber meets the road on what it is that's required of lawyers and judges to make justice happen. And special thanks to Sydney and Dorothy for explaining to those of us who were not part of the GAO world how that worked. And so, yes, it was a lot of hours on this committee, but fantastic, I think, fantastic result. Evan, the only question I had was that a gentle, when you said, would you like to submit it as it is with all the crud on it? Or would you like
no.
Make it attractive?
We'll clean it up.
You'll take it with that. All right. I didn't know if that was just you gently saying, don't be such a slob.
I'm sure all of us have received emails with attachments with the changes tracked on it before, but I've received several from the government. But anyway, so what I'm hearing is that there's consensus on the subcommittee to accept the changes, clean it up, and move for adoption. Is that what I'm hearing? So, okay, great. Let's see, Mary, you got a question, and Fran, you got a question or a comment. Let's start with Mary first.
Sorry if I can hit the right button here. There we go. I just had, and I may have missed it in all the material and stuff. Is this comment directed for abuse and neglect and like juvenile things, or does it also address guardian ad litems who are appointed in incompetency matters? For example, when the respondent is appointed a guardian ad litem in those matters.
Juvenile.
Again, pardon?
The juvenile matters and private TPRs and possibly even custody cases.
Okay.
But primarily juvenile.
Thank you.
Okay. All right, Fran, you're next, and then Dorothy.
So I litigated these cases for 15 years, abuse and neglect. I know that Sydney has, I know that Carmen has, I'm sure that Judge Mitchell has. And I have, many times cross-examined a guardian ad litem on his or her report. So it just troubles me that we're going forward with this, and the language that if the court orders the lawyer to serve both does not remove that conflict. The conflict is still there, but the opinion is basically telling judges it's okay to do this. And it just troubles me. I mean, we learn, in law school, right, to trust your gut. And my gut is telling me this is just not a good way to go. But it sounds like, Sydney, you guys struggled with that in the subcommittee as well, but I just wanted to share that concern. And I also recognize I practiced law for a long time in Chatham County, where you had 3 lawyers on the list, and it's a struggle to get lawyers to do that. I get that, but it's still a conflict, in my opinion, for an attorney to serve as both.
Fran, you are speaking Dorothy and I's language. That was most of the meeting that we had. And Dorothy and I came down on the line, frankly, and Dorothy, I'm sorry, I'm speaking for you, so I'll let you speak for
You're
yourself.
doing a
But what
great
I
job
would say,
speaking for us.
yeah, is that we thought that it should be 2 different people. But again, it came down to what you were saying in Chatham County. You have 3 attorneys, and how are you going to deal with that? And so Dorothy and I just came down on the line of, if we're going to move forward with this, we want to make sure that the attorneys who have to serve in the dual role have cover from the judge, so that we aren't doing things that we think are inappropriate. But there are counties, as you already mentioned, that do this on a regular basis and have conflict attorneys that are even doing it for the guardian ad litem program. And so it's not just private TPRs. These are active abuse, neglect, dependency cases, where Johnston County, for instance, has a conflict attorney who has 45 cases right now, and he is the volunteer and he is the attorney. So this will have, I think we just really struggled with that, but I completely agree with you. I think that in an ideal world, where I think we should actually aspire to as attorneys, is that there should be 2 different people in that role, so there isn't that conflict.
Great, thanks, Sydney. Dorothy, you had your hand up.
Yes, I would agree wholeheartedly. And Sydney has done a phenomenal job, as I said, of speaking for both of us. Fran, she is right. That is the one thing that we kept reiterating every single time we spoke as a subcommittee. I also want to just point out that there was quite a bit of discussion as to the funding or lack of funding that should guide or motivate our, thinking and process in this. And I think we did a really good job of staying away from that and not letting that be the guiding force behind whether or not we should move forward with something like this. But to go to one of the questions, I think, Andrea, you asked the question about, is there a reason not to include it? I don't think that there isn't a reason not to include this discussion, or at least this inquiry as to incompetency hearings, but the particular inquiry that we got was about the guardian ad litems in 7B cases. So I think that we were kind of constrained in that to deal with that particular inquiry. So, but I don't see a reason why it couldn't also venture out and, another one could be looked at for those incompetency proceedings. But I think that we are at it, as Sydney said, we had to figure out a way to, make it work all the way around. And this was the best that we could come up with.
Thank you, Dorothy. Judge Bell, you got your hand up.
Yes, sir. Thank you. I just wanted to say, I think we're venturing into an area where we were talking about in the Issues Committee yesterday, when we're talking about deserts, attorney deserts, places where there are not enough attorneys to handle cases, and what are strategies for dealing with those. So just a note that somehow we need to tie this discussion in with the Issues Committee so that they can work together on this.
Yes, that's true. Thank you so much, Judge Bell. And Andrea, you got your hand up.
So if we all felt like it would be worthwhile to include incompetency proceedings as well, how do we expand this, or do we have to get a formal inquiry? Can we as a committee move to expand it? Because I feel like it should be looked at in tandem.
Well, it's like the possession of contraband issue. We try to take the narrow question and not try to expand its boundaries as a general rule. Now, there can be a recommendation, like we'll get to here on the 1.6 issues, that the Ethics Committee has sent it back to review for rule changes as opposed to just an opinion on the narrow facts. But right now, this opinion is tailored to the factual situation, and that's the way we usually do it.
Okay.
So, and so I know Bert Kemp has texted out, don't judges have concurrent jurisdiction with the state bar on ethical matters? Is that, that's a good question.
Yes, they do.
Okay. Yeah. I hope so, because we deal with judicial cover every day. It's like, look, as long as the judge covers us and wraps us in that powerful judicial blanket, you know, we feel comfortable. And so I just wanted to double check. Thank you.
Yeah,
Is
and
that
I think most
what
judges are
is
used
around
to
your
dealing
neck,
with-
Bert?
You know what? Darren's been texting me all meeting about my scarf. I'm trying to bring a little.
It's your judicial blanket.
You're doing a great job, Bert. No, but that's to that point. And just to clarify, I think this kind of goes to what you were saying, Fran. You know, the look at one of the rule issues and the real issue of this being a conflict, this creating some tension. You know, we see that so often. I know we get calls on the ethics staff from folks that are in the middle of trial and they're like, I've got an obligation to withdraw from this case, but the judge is saying I should stay in. What should I do? At that point, it's our advice that, you know, judges have concurrent jurisdiction. If a judge is telling you to stay in, then you are not engaging in a violation of the rules of professional conduct, even though you can articulate the very rule that you feel your continued participation would be violating. And so I think that's the situation here with this opinion, and why the opinion comes out with the clause that says, you know, that essentially if a judge tells you, you articulate the professional responsibility issue, the conflict and the potential solution here. And if for whatever reason the judge says, I think you can proceed in this capacity and I'm ordering you to do so, then that essentially doesn't necessarily alleviate the issue you've identified, but at least it has kind of given you some assurance that you're not engaging in professional misconduct by proceeding along with the judge's orders. So it's a tough line, and I understand. I think your question is certainly a good one, but I think that's something that the subcommittee resolved in that regard.
Thanks, Brian. We've got Jack with his hand up, and then Sydney. We'll go Jack first.
Yeah, Brian covered it. Thank you. Brian got it.
Okay. All right. Thank you, Jack. Sydney.
I was just going to add, that's the reason why we actually put the provisions in there, and Nicole did a phenomenal job and had to deal with like 5 billion revisions. So we thank Nicole for her hard work, because we were not a easy subcommittee. But one of the things that we wanted to make sure is that we had the judge inquire as to what role. So it was the onus is now on the attorney, but the judge needs to make a written finding, because that is not oftentimes done in juvenile court, and we need that to be cleared up. And so now it's going to be an education of attorneys in that courtroom to understand what the new procedures are in judges. But we thought that it was really important for us to make it part of the actual record, so that it is now written and everyone knows what the role is moving forward.
Right. Well, if this opinion goes out, we need to make sure that all the judges get copies of it so they understand what the new landscape is, and also get it out to those that practice in juvenile court so everybody can protect themselves. All right, any other discussion, comments? So the motion is that we accept the track changes and clean it up and adopt it for publication. So let's vote on it.
Andrea put her hand up.
Oh yeah, hey Andrea, sorry.
Okay, I'm sorry.
That's okay.
I want to give you all a little background about myself too. I didn't say this earlier, but we are the DSS attorneys for Watauga County. So I deal with this issue a lot, like many of you. And I also deal with incompetency proceedings a lot as well. And I'm going on a comment that Suzanne made to me, and that is that I may be able to make a motion to send this back to committee so that the incompetency proceedings are considered as well. And the reason why I think it's important is it could be that the same problem is in these incompetency proceedings. And if it is, it would be helpful for attorneys that forum as well to know what the rules are. If you all have already discussed that and you feel that that it's not the same thing, then I would be at peace with it, but at least look at it, because if it's the same issue, to me, it makes sense to expand it to that, only to help the attorneys in that forum as much as you're helping the attorneys in the abuse, neglect, and dependency forum.
Yeah, Jack, I'll get to you in a minute, but Brian and Nicole and Suzanne, just as a point of order, are we able to expand the inquiry to something that was not inquired about?
I think as far as, well, yes, I think if the subcommittee or the ethics committee feels that a particular inquiry, you get one particular fact scenario and you realize that it implicates something else, it is possible, if it's appropriate in the ethics committee, to address that something else that's been identified. I think as a point of order right now, we do have a motion and a second for publication. And I think the motion that Andrew's referring to send it back to subcommittee would need to be voted on second, unless I think that I don't think it serves as a substitute motion or something that takes precedence over the motion that is currently on the floor. So I think that could be, I think maybe Andrea's suggestion, maybe that's a question to the person that made the original motion for publication, if they want to accept that as a change or what have you, to withdraw their motion or maybe amend their motion.
Dion, that's you.
Yeah, that kind of puts me, I hadn't really thought about that. And I wouldn't want to make a substitute motion until I talk to the rest of my subcommittee.
And I second it, I believe, and I would be in favor of sending it on, in favor of our original motion, just to let you know.
Yeah, I think I would rather go up and down on our original motion and second, and then if it fails, then maybe consider Andrea's.
Great. Okay. Any other comments?
No, I would just
Jack, yeah.
echo those comments and just say, if you were in these meetings, you would see how the struggle we went through to deal with a very finite question that was before the committee. And, Dorothy and Sydney and everyone else on the committee can speak more competently about this than I can. But what we had to do to go through just to deal with the very narrow issue that was before us, I think that I've been on subcommittees where we expand the topic and appropriately so. In this particular area, because the question was narrow, I think it demanded that we respond with a very tailored response to that specific issue. I think if we tried to expand this issue, and I say this from having sat through hours of these meetings, it would be, I don't think it would really be a realistic way to try and deal with this issue. I think that we have to address the narrowly tailored response to this question.
Okay, thank you. And I think Catherine Fry just put out the correct Robert's Rules of Order on this. So, all right, any other comments before we vote? Let's put up a poll. I don't see anybody's. Let's vote on Dion's motion.
All right, and this is voting on the motion for publication. All right, and that looks like voting slowed down, 25-1 in favor of the motion.
All right, so we go to executive committee on this then.
Well, actually, no, the ethics committee has the authority to simply publish an opinion. This doesn't need to get approved by the council. It just gets published for comment. And I think that can be, to Andrea's question and point, and I don't know, Andrea, if you're going to request that, essentially another subcommittee be created or what have you to look at that issue. But I think publication offers us the opportunity to see what sort of feedback we get on the opinion. Folks may say, what about incompetency proceedings? And that may give us some guidance as far as whether or not that should be included, or whether we should take that on as a totally separate matter. And I think that's where some of our subject matter experts could really weigh in to the applicability and really ultimately the helpfulness of having all of these addressed in one opinion, or perhaps because they are kind of distinctly separate proceedings, should it just be a separate inquiry that even refers over to the analysis in this opinion? But that's where I think maybe that'd be the best way to kind of see where this goes at this point.
Yeah, Andrea, you may want to reach out to other DSS attorneys and have them review this and comment and respond, which would open the door for reconsideration when it comes back, or file a separate inquiry. Either way. So, okay, we're running a little late here, but the next inquiry is the inquiry of Adams, which is limited representation on a criminal matter. And I'll just say this is, I'm glad this is here. My law firm never makes limited representations on bond hearings ever. We take the whole case or we don't take any of it. And it's always been a problem. And I think Tom Engelman has called them bond pirates that come in. So let's get Nicole to lay out the information here, and then Tom will get you. Okay, Nicole, thank you.
No problem. So I'm gonna, in the interest of time, gonna zip through this. Let me first start out by saying that the subcommittee is not finished with its work on this proposed opinion. I put out a draft with some track changes in it to the subcommittee, but they have not been able to meet to discuss those changes. So this is an inquiry that we received from a lawyer asking if it is okay for a lawyer who is privately retained to provide limited representation and handle a bond hearing for a defendant who has previously been qualified as indigent and has appointed counsel. So the main issue in the opinion is governed by Rule 1.2, which states that a lawyer may only limit representation of a client if it is reasonable under the circumstances and the client consents to the limitation. So the opinion addresses the fact that a privately retained lawyer coming on board may interfere with the client's ability to qualify as indigent status, which could have damaging effects to the client if the lawyer who is privately retained subsequently withdraws from the representation and leaves the client without any representation for the underlying criminal matter. The other issue is that the privately retained lawyer needs to be aware of the client's case, meaning that they should have conversations and communications with the DA, they should review the discovery, talk to appointed counsel, and make sure that the client's interests are going to be protected, notwithstanding the lawyer's limited representation. So as part of the limited representation, the lawyer needs to explain these issues to the client and get the client's informed consent to limited the representation with the understanding that it may have an impact on their indigent status. The opinion provides that whether or not a defendant qualifies as indigent is a legal question to be determined by the court, and it is not governed by the rules of professional conduct. So that specific question is not answered, only that it directs that the lawyer must think about that issue and determine whether or not the limiting representation would be reasonable under the circumstances. The proposed opinion concludes that at the earliest time possible, the retained lawyer must inform appointed counsel of his involvement. The subcommittee talked about that, the fact that sometimes things happen so quickly that the retained lawyer to handle the bond hearing happens before the appointed counsel is identified. So the opinion recognizes that and states that at the earliest time possible, the lawyer should be reviewing discovery. They also talked about that the discovery might not be available immediately, but whenever, as soon as they can review the discovery, talk to appointed counsel. The subcommittee also talked about that even if the appointed counsel is not identified until after the bond hearing is already resolved, that the lawyer should still communicate with appointed counsel and let appointed counsel know what they did so that appointed counsel can be prepared with the rest of the representation of the client. The subcommittee also then talked about whether or not there is a difference in misdemeanor cases versus felony cases. Is limited representation allowed in misdemeanor cases, but should never be allowed in felony cases? The facts of the inquiry do not distinguish between misdemeanors and felony cases. So originally that question was not answered in the opinion, but because of the subcommittee's concerns about that, I did talk to Brian after our subcommittee meeting, and we decided that we would add an inquiry to address that question. And so the question is the analysis in the opinion applicable to lawyers who limit representation of a criminal defendant in both misdemeanor and felony cases? So the answer to that question is yes. Under Rule 1.2C, a lawyer may limit representation if the limitation is reasonable under the circumstances the client gives consent. Whether the limitation is allowed should not be contingent on whether or not the matter is a misdemeanor or a felony, but instead should focus on other factors such as the level of charges. So, what is the client being charged with? And for example, a series of multiple felonies will result in a significant punishment. So punishment and the level of punishment is also a key factor. And whether or not a lawyer should provide limited representation. And also another factor consider is a single misdemeanor may not cause any problems or significant punishment for the client, and maybe limitation is appropriate in those circumstances, but then a multiple number of misdemeanors that rack up or increases the punishment level may mean that the lawyer should not limit their representation. So the opinion basically is saying that, the lawyer needs to look at the totality of the circumstances and consider these other factors to determine whether or not limitation is reasonable under the circumstances. So like I said, the subcommittee has not reviewed this new inquiry that I have added. They haven't had a discussion about it. And so my recommendation is that we keep this in subcommittee so that the subcommittee can continue to work on the opinion.
Thanks, Nicole. A lot of moving parts on this one. Tom Anglin, do you want to weigh in here?
Yeah, and in light of all those moving parts, and well stated, by the way, Nicole, I move that we send it back to subcommittee for continued discussion. I think we're close to finishing up something. And so hopefully by next quarter, we'll be in a position to recommend publication of some FEO. So I move that it go back to subcommittee.
Is there a second?
I second.
All right, any discussion? I think Bert, you're on this subcommittee, and Takia and Brad. And
so
John.
is John Webster's on as well.
Yeah, John. Any discussion from any committee members?
No, I do feel like we need to take it back to subcommittee. Like they said, there are a lot of moving parts, a lot of things that once you get into it, you realize it's not as simple as you think it could be. So yeah, I think that's the appropriate motion.
Okay. Brad, you want to say anything? Nope. Okay. All right. Any other discussion? All right. Let's vote on it. Back to subcommittee.
All right. That appears to be unanimous.
Great. Okay, number 6 is inclusion on allied professionals list of preferred lawyers. And this is interesting, acts of non-lawyer third persons and a lawyer's responsibility for that. Brian, you've got this one.
Sure. This is the result of an inquiry that we received about whether or not a lawyer could be on an allied professionals referral list. Essentially, the scenario of what you call a medical professional or some other professional that essentially has a list of lawyers that they will provide to their client or their patient, whoever it may be, and say, you know, hey, if you need a lawyer, take a look at this individual. Now, some nuances come in here and some tricky spots come in because you may have a situation where, let's say, a medical professional chooses to treat somebody differently. Maybe they will bill them differently depending upon whether the person has a lawyer. If you have a lawyer, then you can pay at the end. If you don't have a lawyer, you need to pay up front, or perhaps refusing treatment altogether, depending upon whether the person has a lawyer. So the initial draft is in your materials of this opinion. The subcommittee met over the past quarter and discussed the draft. I think at first thinking that, you know, this was, we're heading in the right direction on the opinion, but I think the conversation turned a little bit as we started talking about the ripple effect of this opinion and really whether or not we already have sufficient opinions in our archives, our repertoire of ethics opinions that really address the key points of this. Not to mention the difficulty in holding a lawyer responsible for a third party who you don't really have any sort of control over. So at this point, it's my recommendation that this remain in subcommittee. It's still being reviewed, and whether or not we get to a point where we have an opinion to publish or whether there's going to be a recommendation to withdraw the opinion and perhaps issue an article to offer some perspective on this is going to be kind of, I guess, remains to be seen. But my recommendation would be that it stay in subcommittee.
Thank you, Brian. Kevin, you're chair of this, aren't you?
Yes, Evan, and I think Brian captured it perfectly. Certainly thanks to him for drafting the initial draft opinion, and Amy, Ellen, Davis, and Warren for participating in the hearing or the meeting we had. He's right. We started out saying this might be perfectly on point, to a point we almost scrapped the entire opinion and then came back around and said somewhere in the middle. And I think once we get that updated opinion and discuss that more, we'll have better information for the committee next time around. So it would be my motion to keep that in subcommittee. Right. And I don't know if any of my folks on the committee would also like to make any statements, but that would be my motion.
Let's get a second and then we'll get some statements. Is there a second?
I'll second.
Thank you, Amy. All right, anybody else on the subcommittee want to comment before anybody else? All right, no comments. So the vote is to send it back to subcommittee. Let's put a poll up on that.
All right, that appears to be unanimous.
Great. Let's take up reconsideration of prior inquiries. This is 2021 FEO3. This is having to do with charging fees to opposing parties in residential real estate closings. And Brian, this is you.
Yes, so this opinion was published over the past quarter. The opinion addresses the situation where a closing attorney is representing the buyer, but the seller to that transaction is independently represented. And the closing attorney seeks to charge the independently represented seller a fee for maybe document review or something like that. This is an inquiry that really is based upon a number of calls that we have received on the staff from folks, some people feeling like, particularly sellers, attorneys, feeling that that type of charge is totally inappropriate, and buyers attorneys feeling that it's very much appropriate because they were seeking originally to represent both the buyer or maybe provide legal services to the buyer and the seller in the transaction. And now that they have to read another attorney's work, then they can't use the kind of the status quo, the templates that they use. And it's going to require additional work, and they end up passing those charges onto the seller. The opinion says that those types of charges are not appropriate, that essentially the closing attorney in that scenario cannot charge an independently represented seller or independently represented party for work completed unless that seller has agreed to pay those charges. Should the closing attorney decide, in light of the additional work, I need to now charge a higher fee to my client, the buyer, that is permissible so long as the fee charged is not clearly excessive. The opinion, again, it's been published, it's in your materials. It was previously published under a different version. We got some comments with some suggestions for tweaking it. The subcommittee did revise it. So this is the second round of publication, and the second round of publication produced 2 comments, both of which were favorable to the opinion. So I believe, we look to the subcommittee for recommendation. I did share this with the subcommittee, and Alan LaCroix, the prior chair of the subcommittee, is now on grievance. And he wanted to, he asked me to send over his support for the opinion and his support for a motion to adopt or to send to the council for adoption.
Thank you, Brian. Yeah, the comments were positive. So Judge Cleland, do you want to weigh in on this? Make a motion?
I don't think the judge is with us.
Okay, he's not here. All right, John, Webster, Amy, let's go to John first.
I don't really have anything to add. I think it looks good the way that it is. I didn't start out agreeing with it, but I do now. And
so you want to make a motion to adopt?
I would at this point.
All right. Is there a second?
I'll second that motion.
Okay. Amy, you want to make any comments since you're on the subcommittee?
I don't have any other comments. I think we've kind of gone around in circles, but like we said earlier on one of the opinions, the fact that our comments have come down so drastically from where we were last time, I think is a sign we finally hit the right note.
All right. And Christina, you're a real estate person, so you were right in the eye of the storm here. Do you want to say anything further?
No additional comments. I support the opinion as written.
Okay, great. Well, there's a motion to adopt and no more comments. Let's vote on it.
I see Andrea has her hand up.
Oh, hey, Andrea.
Hey, I
always miss you.
It's fine. I am favorable to this. I think it's a good opinion. I do have a question for the committee. If somebody could help me with distinguishing between this and attorneys who charge for the seller, a buyer's attorney who charges a seller for satisfying a mortgage. Those fees in recent years have become more common, and I didn't know if there was anything that distinguished this situation from, again, buyer's attorneys charging the seller for paying off their mortgage.
I guess as a point of clarification, are you talking about the seller who is independently represented by counsel or is not represented by anyone?
No, sellers who are independently represented by counsel. I would say, in the last 5 years, I've seen it come up a lot, and I just didn't know if there was any distinguishing factors between those two situations.
Yeah, so that's where opinion number 4 comes in, and that was one of the revisions following the first round of publication, where the prior answers to the different inquiries started off with, essentially, can closing attorney charge the independently represented seller a particular fee? The answers were no, unless X, Y, and Z happens. Opinion number 4 takes a different approach, and it says basically to that particular issue, can that fee be charged to seller? Yes, provided that basically seller has provided that advance notice, there's no objection to the fee charge, and also that buyer consents to that fee as well, because really they brought up this question of who is the beneficiary of that work. Closing attorney is satisfying a mortgage that is really, you look at it as the seller, it's satisfying, they clearly are obtaining a benefit, but also that mortgage, that lien is being removed from the property as well. And that is a benefit to the closing attorney's client as well. So really there's mutual benefit there. And so that's why we changed it to say that the fee essentially is presumed appropriate as long as that advance notice is provided to the seller that, hey, I'm going to do this, and I'm charging you for not for reviewing the documents that you have decided to send over or what have you, but because I'm providing legal services that really benefit both both people here that I can provide you advance notice of that fee being charged. And as long as it's not illegal or an excessive fee, and the seller doesn't object to it, then that fee is going to be presumed appropriate.
Okay, thank you.
Sure.
Any other hands up?
I don't see any.
Andrea, you still got your hand up though. So, okay. Any other comments? Don't see anybody. Let's vote.
Right. And this is for the motion is to adopt, to send to the council
Yes.
for adoption.
Yes.
And that is unanimous.
Fantastic.
In favor.
All right. And the last reconsideration here is on the departing lawyer's email account. And this affects several Rule 1.3 and 1.4. Suzanne, this is yours. Can you set us up?
Sure. This is a proposed opinion that talks about what the law firm's duty is as to the email account for a lawyer that leaves the firm. A proposed opinion has been published for comment. The proposed opinion provides that the law firm has to keep the email active for a period of 3 months and has to place an outgoing auto reply message on the account for 3 months, unless there are special circumstances where a shorter or a longer time period would be appropriate. The proposed opinion talks about what has to be included in the auto reply message. It states that it must include notice of the lawyer's departure, and if appropriate, the response must provide new contact information for the departing lawyer. The opinion states that it may not be appropriate to just provide the departing lawyer's contact information if the lawyer has perhaps become unfit to practice law for whatever reason. We received 2 comments. The first comment from David Levy on behalf of Hedrick Gardner. He does not believe that the law firm should be required to include the departing lawyer's new contact information. He seems to believe that that is too much of a burden for the law firm to have to track down and keep up with the departing lawyer's current contact information for the 3-month period. He's requesting that the opinion say that the message may include the departing lawyer's new contact information, but it does not have to include it. He also has issue with the wording in inquiry 2 that states that the law firm has to include the departing lawyer's contact information if appropriate. He says he doesn't understand what is meant by if appropriate. That actually refers to the second paragraph of that inquiry where we talk about the lawyer perhaps being unfit. That could be easily fixed with a sentence saying, if appropriate, refers to the lawyer being unfit. So that particular issue could be easily fixed. The second comment came from Paul Saunders on behalf of Williams Mullen, and he is concerned that the way email systems are set up, and I'm sure you've all experienced this yourself, the first time you send an email to somebody that has moved, you get a message back saying they've moved. If you keep sending emails, you don't get that message again. You get one message. And that's set up that way, I guess, because otherwise there can be like an infinite loop or something like that. So he wants the opinion to say specifically that the lawyer meets the burden if somebody gets that first email. They've met their burden. They're not responsible for somehow figuring out how to continue to send emails every time that person emails. And then they also would like to request a different time period from the 3 months. They say usually there might be a flurry of emails right after the lawyer leaves, and then they tend to drop down. He would like the opinion to say that it's the lesser of 3 months or the expiration of a 2-week period during which no substantive emails have been received.
Okay, thank you, Suzanne. Kevin, you're chairman of this committee too. You want to weigh in?
I can weigh in. I was not actually the chairman. I think we lost our chairman.
Oh,
Yeah,
that's
it was Bill Mills, and he's.
Oh, okay. All right. Well, you're now the acting chairman. So, you want to weigh in, make a motion?
We have not discussed it as a subcommittee in any terms as far as the comments that did come in. You could look at it two ways, and I could see how they can be answered by what's there, or I think we could go back to subcommittee, but I think the opinion already actually addresses what the comments are geared towards.
All right. Well, Warren Savage, you're co-chair now. Do you want to make a motion? Make a motion?
Yeah, I'd move for publication. And I'll comment once that motion's on the floor.
Well, I think it's already been published, so I think the motion.
Move for adoption. Yes, move for adoption.
Can I speak on that?
Yes, Suzanne, please.
I would like to make very small tweaks, but that might require it to go back to subcommittee. I would like to clarify that the if appropriate language refers to what is discussed in the next paragraph. And I would like to hear everybody's thoughts on maybe including a sentence that says that addresses the fact that they're only going to get one email, and that meets the burden. Or is that just implied? Did everybody feel like that was understood, that if your email?
I guess I felt like that was implied, and that I don't know.
So for me,
I would withdraw my motion if Suzanne wants to take it back to subcommittee, definitely, because I don't want to put something out there that
my thought is that I can. My thought is that I can pick if everybody feels like the only one-time email is not an issue, and if nobody feels like the 3-month period needs to be changed to that 2-week either or, I feel like I can change the if appropriate with just a non-substantive tweak, and then I can do that, Brian. We could do that, right, Brian, and still publish it or still send it on.
Yeah, I mean, if it's I think it's tough because you're talking about language that isn't currently before the committee, and so that's what gives me a little bit of pause. I mean, it's one thing to articulate a single sentence. But to get that up before the council, I think if there's any sort of additional language and there's discussion about that, then it should go back to subcommittee. But otherwise,
I think I can do it in one sentence. I can read it, or I mean, whatever you think.
Yeah, I think that language would need to be before the committee, even if it's just read out loud. And I think that's what I'm getting at. Otherwise, the committee is approving language that they haven't technically seen yet. They've just been kind of.
All right, David Allen's got his big paw in the camera.
I've tried to be silent, but I don't think we need any clarification on the appropriate thing. I think it is fine the way it's done. There may be other circumstances, besides being unfit. I mean, somebody, there may be somebody has resigned from the practice. They've turned in their stuff with the state bar and they're no longer a lawyer. There may be someone someone's gone to be a judge, and we don't want to supply that judge. We don't want that judge to get inundated with a bunch of email from, from folks that he or she doesn't need to get. So, I mean, it also does apply to the stuff that's mentioned when the lawyer may be unfit for service. But it also, I mean, there may be other circumstances where that's it is just inappropriate to supply that. But I think the 3 months is great, and I think a little bit of latitude about including the email, besides just when have been referred to the LAP program or something like that, is probably appropriate to leave some discretion there, and I'd send it in as is, or send it for adoption, I guess, as is, which I think was Warren's motion. I'd second that motion if it needs to be.
All right, Tom's up first. Tom Anglin, and then Warren, you're next.
Let me take my hand down because I'm not really sure where we are. with a motion. My concern was this, the comment that deals with substantive, that opens up all sorts of questions if we're going to go down that path. But I guess I'm gonna take my hand down and wait until we actually have something to talk about.
All right, Warren.
I don't want to withdraw my motion, especially now that it's been seconded. And here's why. I think number one, I think it's clear enough. It's in the opinion to number two. It's very clear to me that there may be other things that make it appropriate to say more than just that the lawyer is mentally impaired or whatever, according to 2013 FEO 8, and that those things just need to be thought about when you do this. This is not just throw up a auto reply and then you don't do anything. So I think it's fine as is there. And as to the question, what David said about the 3 months and the request to say 3 months or 2 weeks, whichever is lesser, I'd completely disagree with that, given this is going to apply to all lawyers. There are many lawyers that don't hear from their client for a long time between emails. And if that account is shut down out of the blue, as far as the client is concerned, and they never hear anything back, except that account no longer exists, assuming they even get that, that's problematic to me. 2 weeks is just not enough. So I would encourage us to go ahead and send this to the council for adoption.
Okay, that motion has been renewed and had been previously seconded. Anybody else want to weigh in on this? Do I see any hands? David, you want to say anything? Nope, you're off of mute. I mean, you're not muted. Okay. All right. This is a motion for adoption and send it to council.
That looks like it's 26-1 in favor of the motion.
All right, it passes and it'll go to executive and then to council. All right, the last item is the number one item, and I'm going to have to turn the chair over to Catherine Fry for running this show. Catherine?
Yes, thank you, Evan. So we're going to talk about proposed 2020 FEO 6. Commenting publicly on client information contained in public records. I think Suzanne staffed this, and then Evan was the chair of the sub. So Suzanne, do you want to give us a brief introduction of where we are?
I'm actually going to pass that on to Brian, who did a CLE on this yesterday, and is very up to date. He's got everything prepared already.
Yeah, so let me get some slides. We'll talk about this for the next hour. No, I'm kidding. So the background on this one, somewhere mid 2020, we got an inquiry from someone who was in a high profile case, who essentially, as a result of that case and the favorable result he obtained for his client, started getting like media requests, CLE requests, podcast requests to go on and talk about the case, his experience, and really the public aspects of the case. Lawyer contacts client and just says, hey, heads up, I've been getting these requests and I'm planning to participate in this. I hope that's okay with you. To which client responds, please don't. I really don't want you to do that. I want this case to be over with. It's drug on for too long, and I just don't want to see my lawyer out there speaking about this case and speaking about my case and my life. So lawyer contacts us and says, I don't have to follow this directive to not speak about the public aspects, right? Surely I can talk about what happened. I was just making a courtesy call to the client, but really I can talk about what happened publicly. And so that's what generated this inquiry. we brought it to the ethics committee and, took a look at not just our rules, but then looked at what other jurisdictions have done on this particular topic. The topic being what sort of confidentiality protections, or how does the rule on confidentiality, Rule 1.6, impact information that's in the public record. The opinion originally drafted said that essentially information that's in the public record is to be kept confidentially. It is supposed to be confidential. The lawyer cannot disclose information obtained during the course of the representation, even if it is currently in the public record, without client consent, or unless one of those exceptions applies that you see in 1.6b, or disclosure is impliedly authorized. Clearly, we didn't have client consent. There's no implied authorization or implied need or implied consent, excuse me, for disclosure because the representation had ended. And there were no exceptions in Rule 1.6b. So we were left with the conclusion that, yes, even though it's public information, it's information you acquired during the representation, and therefore you must keep it confidential. You cannot talk about it publicly. Well, we published that opinion. As you can imagine, lots of people did not like that opinion. And to be candid, staff wasn't terribly thrilled with it either. It felt like it was an impractical, it felt like the right decision, but it felt like an impractical sort of way to address this issue, a very common issue. And frankly, something that lawyers have been doing for some time, talking about only the public aspects of what happened in trial earlier that day, things of that nature. So we got a lot of negative feedback about that opinion. I think it generated the most comments we've ever received on an opinion. We found ourselves back in subcommittee then really addressing, do we change the opinion, or if we think the opinion is correctly drafted under the rules, do we need to change the rule itself, the rule on confidentiality, to allow a lawyer to speak about stuff that actually is public? That led to a lot of debate in the subcommittee about the necessity or lack of necessity for an actual rule change. The gist was that we ended up at an impasse all the way up until October of last year when Eben, as subcommittee chair, brought this to the full committee and said, we've got a split vote. There's half the subcommittee thinks that it's appropriate to amend the rules to allow lawyers to talk about stuff that's in the public record, and half the subcommittee thinks that we should not change the rule at all. That essentially confidentiality, it is what it is. It's important. It's a pillar of our attorney-client relationship, and it shouldn't be messed with. If that means that somebody who is representing a client cannot go and talk about their case at a CLE and have to rely on somebody else to talk about it, so be it. But confidentiality essentially needs to be prioritized over the ability to participate in educational opportunities and things of that nature. So the full committee expressed at the October meeting, expressed their desire to see some type of proposed rule change. Because I think we're, again, going around articulating the different reasons for both sides, but also recognizing that essentially the legal profession has been treating this information as being, I guess, eligible for disclosure for a long time and has not produced client harm. And it kind of creates a situation where essentially we're talking about, we could either go with the original opinion, which would drastically change how lawyers handle this type of information, public information, or we could change the rule, which would maintain what really is the status quo in the profession. Change the rule to keep everything the same. So it's so the full committee expressed a desire to see some type of rule amendment. Suzanne and I got to work after that committee meeting and started drafting up some potential rule amendments based upon the feedback that we heard at the full meeting. And presented those to the subcommittee, and I'll let Eben take over from here because I think we actually have some consensus on what's ripe for the committee's discussion and consideration as far as an amendment to the rules of professional conduct that would address a lawyer's responsibility with regards to client information that is now in the public record.
Okay, Eben, you want to jump in and tell us what your subcommittee has reached a consensus on?
Yeah, I'm getting to that right now. But first, I just want to say that this has been quite a journey with this subcommittee and Suzanne. We really spent a lot of time on this with some really hardworking people. as we navigated 1.6 and then changes in 1.6 and then changes in the comment of 1.6 and Rule 1.9 with new comments. This has really generated a lot of angst with members of the bar because a strict reading of Rule 1.6, which is confidentiality of information, it's not just confidential information. 40 states and the American Bar Association say that a lawyer may not disclose any information obtained during the course of representation without the client's consent. And so that means that you can't talk about the case even though you were in court and everybody else heard it. You can't talk about it at a CLE without client's consent. You can't talk about it on a podcast. And I'll just say as an aside here, the original inquiry was from Bill Powers that asked this lawyer to be on his podcast, and the original lawyer, Bobby Kahn and Monroe, had the foresight to call his client and ask for consent. So what we've done, it was really difficult to find a way to modify Rule 1.6, which is the confidentiality of information. It's a much broader concept than attorney-client privilege. And so we look to Rule 1.9, which deals with former clients. And Rule 1.9 already had sort of a window into using information from former clients. And so what we've done is we've added a comment to Rule 1.6, which is in your materials, and we'll read it if you want to. And we've made substantive changes to Rule 1.9 and added a comment. And so this kind of balances the protection of the client and the client's information and the confidentiality of that information versus the common sense and common practice of information that is contained in the public record after a case is over. And it's a delicate balance, and it's been a difficult process to try to reach consensus on this. But it does open the door now for lawyers to disclose and talk about information that is contained in the public record. We tried to deal with the issue of generally known, and that is difficult to define. So we've limited it to contained in the public record. So,
Evan, would it be okay if I share my screen so we can kind of
absolutely everybody can see it, and then
I want to just kind of make sure everybody's on the same page here. So if I was going to break down what's being proposed, or at least what was I guess the subcommittee was discussing, it's really kind of two things. One is this comment to Rule 1.6 that addresses this issue of, that we had brought up in the comments to that original opinion, the feedback on the original opinion. Are you telling me that the information I learned during the course of the representation with regards to legal research and other expansion of legal knowledge is confidential? And that's something that I think everybody on the subcommittee agreed, no, that should not be encompassed by Rule 1.6. And so the proposed comment that you see the language in comment 1 to Rule 1.6 addresses that essentially kind of clarifies, again, information acquired during the professional relationship with a client does not encompass information acquired through legal research or expansion of the lawyer's legal knowledge, even if acquired during the representation, as the client does not have any reasonable expectation of confidentiality of such information. This feels like a very practical sort of common sense thing that I think everybody would generally agree upon. But we felt like it was necessary to clarify that because it did raise the question based upon the actual text or the reading of the text in Rule 1.6. Moving on to Rule 1.9 brings up the other issue of, well, what about the information that occurs publicly or gets put into a document that gets put in the public record, is discussed or testified to at an open hearing, things of that nature. And that brought up really, it kind of hit on the notion that we heard a lot of feedback from on folks saying, well, I thought that I was allowed to talk about things that are generally known, and isn't something generally known if it was disclosed at a hearing. The rule 1.9 does not really say that. It previously allows you to use the information that's generally known against a former client. It's a very specific context of using it, and only when using it to the adverse effect of your former client. Because 1.9C2 goes on to say that a lawyer shall not reveal information relating to the representation except as the rules provide. So that term generally known not only is really squishy and hard to define, but I think it was causing confusion. So we looked at really both those concepts in 1.9 C1 and C2. And that's where you have in C1 kind of an amendment, getting rid of the term generally known and basically saying a lawyer can use that information to the disadvantage of that former client if that information is contained in the public record, was disclosed at a public hearing, or was otherwise publicly disseminated. Or a lawyer, of course, cannot reveal information regarding the representation of a client, but can disclose. That general rule still is kind of our fixed star. But a lawyer may disclose information that's otherwise covered by Rule 1.6 if it's contained in the public record, if it was disclosed at a public hearing, or was otherwise publicly disseminated. But then there's a caveat there that says essentially that permission to disclose does not apply if the disclosure of the information would be embarrassing or detrimental to the client. So it kind of puts in an additional layer that the lawyer needs to consider. Is my disclosure, while it may have occurred publicly and I'm eligible to talk about it, if it's going to be embarrassing or detrimental to my client, then I cannot talk about it. And the comments that are being proposed for addition here kind of clarify that you'll see there in comment, I guess it'd be proposed comments, new comments 8 and 9. For one, the notion of revealing information usually is information that's already been kept secret. And so there's no issue of revealing information that has already been revealed. And so that's the reasoning behind this new exception. But that also, if there's ever a question as to whether or not the disclosure of this type of information is going to be detrimental to the client, that is really on the lawyer. A lawyer should elevate the client's desires over the lawyer's desires, and a lawyer should reach out to, if it's unclear about the detrimental impact, a lawyer should reach out to the client to see what their opinion is on this type of disclosure. This was done after a lot of discussion, as you can imagine. Even the notion, I know one thing that came up a great deal was this question of, what's otherwise publicly disseminated. And I think that's something that is not as squishy as generally known, but it's admittedly squishy, and hopefully will be, again, interpreted. The rules are supposed to be rules of reason, and they can be that term can be interpreted reasonably as to whether or not something has or has not been publicly disseminated. But those were kind of the two concepts. One in 1.6, common sense sort of thing. 1.9 is really kind of codifying I would say it's codifying how lawyers have been behaving and treating this type of information for forever. And also to the point of it not being detrimental, or at least not producing a lot of grievance complaints against attorneys for doing this very thing that the rules would now say. So that's the language that's before you, and this information is in your materials as well.
Yeah, thank you very much, Brian. That was very, very helpful. This is really kind of threading the needle on a lot of issues, protecting the public, protecting the client, protecting the client's information, and also trying to square the circle with what is common practice, what is helpful to lawyers at CLEs, which also raises the bar of everybody's practice, and just common sense. So we've got, the rule 1.9 applies to former clients. We certainly didn't stretch it over to the 1.18 prospective clients, and the rule 1.6 is still stands as a strong signal and a strong rule that information from the client and received in the course of representation certainly has a strong badge of confidentiality. So we've lost several members who were really helpful on this. We lost Amy Richardson, and we've lost Judge Pittman. I don't think they're on this call. And I think Ellen Murphy, I don't see Ellen here, but we've got Todd Brown and Dion Fortner. Catherine, if you want to call on them. And I'm going to make a motion that these changes be adopted.
I think that'd be a motion for a publication.
Okay, motion for publication then.
I see we have some hands up. Do any of Dion or Todd, either one of you have additional comments before we address the questions?
The motion needs to be seconded.
I was going to say I will first second the motion made by Eben. My comments are brief. My guiding star has always been and remains that we protect the public. And for those of you who heard my comments about these particular rules will understand that has always been my focus. I believe that the interplay now of the changes between Rule 1.6 and Rule 1.9 address my concerns about protecting the public, quite frankly. And I am very comfortable with the language. I support it. And I commend Eben for his leadership and the good work of the subcommittee, and especially Brian and Suzanne for their great work. So I'm fully in favor of this.
So we have a motion and a second. Dion, did you have any additional comments, or we'll move
Probably
to discussion?
none that really help, other than I do want to tell you that when Ellen and Amy, their work on the committee was really helpful, as their positions really put them in a place of helping us drill down in this language that is so hard to understand. And I do think the specifics that we have now help us to know what to do and what not to do. And I really appreciated Todd kind of continuing to bring us back around every time to inconsistencies that may be in 1.6, or that 1.6 might bring to our revision to 1.9. And I think that we've addressed them now, but I'd like to hear what everybody else thinks.
Excellent work. Bert, you had your hand up. You put a question in the chat, which was whether or not there had been a grievance in this area. And it looks like Brian responded, to my knowledge, there's been no grievance in this area regarding a lawyer speaking about public information. So I'm going to move to Stuart.
Thank you, Catherine. So my question is this: so if you look at the language of Rule 1.6, subsection A has a clause in there that says, shall not reveal the information unless the client gives informed consent. And then it goes on and says that, in this comment that we're adding, that this doesn't cover this type of information. And in Rule 1.9, I don't see that same caveat for the former client giving informed consent, but that strikes me as something that could be done in that context, is that you call up the former client and say, hey, former client, it would be very helpful if I could discuss your case at the CLE. We have this issue come up. Do you consent to that or not? And that would enable me to discuss not only publicly available information if these revisions are passed, but also anything. And I do that. I did that recently with a client and have been discussing his case quite a lot because he wants to help, the greater good and the development of the law in this area. So I like the changes that the subcommittee came up with. I just would like to see something in Rule 1.9 that says that the client can give informed consent to allow discussion of information outside of these exceptions that we are adding here.
Thank you, Stuart. Anybody on the sub want to respond to that?
Yeah, I'll respond, Stuart. Thank you. Always good questions that you ask. The subcommittee really drilled down hard on whether or not a client ought to have a veto, which basically means that in every case, the lawyer would be required to seek informed consent to disclose any information. And in terms of 1.6, we pretty much agreed that a client should have a veto, but then we couldn't square the changes that we were making to the terminology with 1.6. Once again, I'm talking about threading the needle here. 1.6, and Suzanne wrote a great article in the State Bar Quarterly titled "The 5 Myths of 1.6," and it really gets to the point. And is that there really is a misconception about 1.6, because I started out with this misconception that 1.6 applied to current clients, 1.9 former clients, and 1.18 to prospective clients. But basically, Rule 1.6 has a big umbrella about information, and so what we've tried to do is maintain the broadness of 1.6, but when the case is done and somebody transitions from a present client to a former client, and there's plenty of information contained in the public record or disseminated in a public forum, it gives lawyers the ability to take that information and use it for educational purposes, with the caveat that if it's embarrassing or detrimental, then should is the word. It's not shall, but the lawyer should seek informed consent. So I don't know if that answers your question.
Eben, if I could offer a quick thing too, I think, Stuart, what you're hitting at is one of the things that I think sometimes gets overlooked in that very first line of 1.9C2, that a lawyer shall not thereafter, with regards to a former client, reveal information relating to the representation as these rules would permit or require with respect to the client. That's what the standard has always been. And that's really the sentence that incorporates 1.6 in all of its protection into 1.9 when dealing with former clients. Now this new part kind of goes on to say, the whole thing about how you can disclose certain types of information, and it's limited to only the information that falls in those categories. But the language, I guess, that first sentence to me is how I would advise folks that, if you're talking about something that doesn't fit into one of those neat categories of public record or disclosed at a public hearing, publicly disseminated, that you're going to have to refer back to 1.6 and obtain that informed consent. And one thing that I know we talked about was this, I guess, the notion that sometimes you can't find the client. The client has gone on, perhaps they've passed away, perhaps they're just a client that is going to have multiple addresses and contact information. And so I think that's where, to your point about bringing in informed consent, it might be that there's, I guess, the question of, there's always an opportunity to add even more clarity to the rule, and perhaps that would be the sentence where you could say reveal information relating to the representation as Rule 1.6 permits, including getting an informed consent to talk about information beyond that. But I think it starts getting a little busy, for lack of a better term. And I think that's where I would advise and have advised folks that sentence is really what incorporates 1.6 with regards to all the other information that this new language would now exempt from 1.6 protection.
Yeah, and Stuart, Rule 3.6 talks about trial publicity, and it kind of gives a little bit of an off-ramp in terms of disclosing information under certain circumstances, and they talk about public record disclosures in that case too. Am I right about that, Brian? There's a little bit of a window there.
Yeah, there is, and that was all the stuff that the subcommittee was considering, the built-in ability to discuss information. 3.6 kind of really harkens on the implied consent for the purpose of the representation, but it's a bit more explicit there. I have to say, one of the other things that came up that the subcommittee discussed was a similar sort of situation that came up at the legislature. This was something I learned about at a CLE when I was presenting on this topic last year, that somebody just pointed out that, you know, the legislative staff previously was statutorily prohibited from talking about this type of information. Not this type of, but like the information that occurs in the public proceedings of the legislature. And they found that to be really impractical and really not the practice. So they amended their statute to allow legislative staff to talk about stuff that was disclosed at their public hearings and public sessions. And that was something that I think we borrowed some of the motivation and even some of the language from that particular statute to bring it over here. So yeah, I guess that's my response to that. But I know we have a lot of hands up right now.
Well, just real quick, Stuart, did you have any follow-up questions based on those comments?
No, that was helpful for Brian. I didn't read it to incorporate Rule 1.6 into Rule 1.9, but that's helpful to know that's how it's going to be interpreted.
All right, I've got a few people, but I'm going to go to Brad. I think he was next.
Thanks. I'm now going to reveal that the compliment that Evan paid me at the beginning of this meeting was horribly misplaced, because I don't know. First of all, it's my understanding that Rule 1.6 is not limited to any time in a lawyer's life with a case. It's not limited to the representation or the representation period. And this may be sort of what Stuart was asking. It may have a little bit to do with what Brian was just trying to explain about incorporation of these rules, but I think Rule 1.6 has to be amended with the language in 1.9C in order for these rules to link up with each other, because otherwise this kind of exception here in 1.9C, when you go back and read 1.6, it still says a lawyer shall not reveal information acquired during the professional relationship, et cetera, et cetera. And the only thing that accepts that in the comment is to say any legal research that I've done isn't information in the course, right? So when we leave 1.6 with that comment amendment, the only thing that we've accepted from this general rule that led to the original conclusion that it had to lead to, that made everybody upset, was you can talk about your legal research because that's not information acquired in the course. Then when you go over to 1.9, it says, you know, a lawyer who's formerly represented people can talk about information, which of course we've already established is now not legal research based on that comment to Rule 1.6. But also it kind of goes on to carve out the rest of this stuff that is a new carve out. And I don't understand how 1.6 and 1.9C with this new language are reconcilable with each other unless the language in 1.9C is replicated in the language of 1.6 under subsection B or some new subsection.
So I'll just say, Brad, we discussed that. Where do we put this? Is it 1.6? Is it 1.9? And the fact that 1.9 and 1.18 for that matter refer back to and try to kind of address how confidential information is supposed to be handled with regard to the type of client you have, whether you're talking about a prospective client or a former client. That's what led the subcommittee to feel more comfortable putting this new language in 1.9C, because it's like we have this existing instruction under 1.9C about how we use the information that we've gathered during the course of the representation to the disadvantage of a former client, or how we're supposed to reveal, or more specifically not reveal, information that we've gathered during the course of the representation. And so I think your point is well taken. It's maybe the question of where is the most helpful location for this information or for this carve out. And you know, maybe that's something where I personally feel comfortable in 1.9, and I think it fits as far as you're looking at your former client responsibilities, because of course the duties to former clients in 1.9, I think we always look at 1.9 and just say that's the former client conflict rule, but it's not. It's our duties to former clients, and that's where I think 1.9, as it originally states, 1.9C2 is what kind of confirms the indefinite nature of the duty of confidentiality on 1.6. But again, I think on any given day, you could make and succeed in the argument that this language it was better, I guess, noticed in 1.6 as opposed to 1.9. So
right. I mean, that as a lawyer, the rule that I'm going to go to when I want to know what I can talk about,
right,
and what is confidential information is Rule 1.6. That should be, in my view, where the definition of confidential information is, and I think that that's what many lawyers would believe. 1.6 is the confidentiality rule. So I need to go to that rule to see what I can and what I can't talk about, regardless of whether it's current representation, former representation, because again, this rule 1.6 covers the former representation scenario. It's not exclusive to the current representation scenario. The rule is confidential information. It has nothing to do with when you're representing somebody. And so it just seems, I mean, I agree with how the committee or the subcommittee has resolved all of this. I think it's extremely well done for, how everyone had to walk between the raindrops. I just think that I really think the language should be in 1.6. And I think it's just not clear right now the way it is that is the conclusion that was reached by the subcommittee. That's just my comment.
All right, I'm going to, unless Brian or Evan, you have any further responses on that,
Bill,
I'm going to move to Bill.
Bill Powers has his hand up.
Yep,
thank you
Bill.
so much. Thank you. And I really, really appreciate the direction the subcommittee has gone on this. I'm assuming these are terms of art, so I don't know. I am a little concerned that the word embarrassment is going to serve as a functional veto vote by a client, because I've yet to see any of my clients who don't think that the criminal proceeding itself or divorce itself isn't somewhat embarrassing. And if it's a term of art, does it no longer become embarrassing if it's already a matter of public record in the discourse of the court? Or can the client say, it's embarrassing for me even talk about this portion of my life and this time who I don't particularly like how I acted during that time period. So is the word embarrassing something that came from some other opinion or language, or I'm worried about that one word, knowing how hard the committee, I really, really like the direction the committee is going with this. And I see where I see the logic behind it. I'm just worried about that one word.
Yeah, Bill, I can offer the embarrassing language comes from a variety of other jurisdictions. It's not like there's a ton of them, but there are other jurisdictions with other versions of 1.6 or addressing this issue. And they focus on embarrassing or detrimental. And I guess I want to kind of emphasize, maybe this is splitting hairs, but I see that the disclosure is the embarrassing thing, not the information itself. It's the disclosure, the lawyer's purported disclosure of the information. Would that be embarrassing? And ultimately, I think you're right. It does create that question in the lawyer's head. And maybe that's something that I think the subcommittee kind of resolved, that, if something is, and that's where the comment comes in about a lawyer should seek out the client's opinion, because if something is going to be embarrassing for the client to see their lawyer on national TV talking about their very public case or what have you, even though it's kind of maybe just because you can doesn't mean you should. And it's ultimately the desire of the rules to say that a lawyer is supposed to elevate the client's interests above their own, as much as it might be beneficial and it might be helpful to teach other people about it at CLE, to make that public appearance, that if the disclosure of that information is going to just be embarrassing to the client, despite the juiciness of that information, that the standard would be to elevate the client's desires and the client's interests over the lawyers. But I think that's the language itself, embarrassing or detrimental, comes from we borrowed from other jurisdictions that we've seen out there.
And Bill, the subcommittee really did a deep dive into that and ultimately came up with the conclusion that it is subjective, both ways, by the lawyer and by the client. But where I think it was Colin Willoughby and several others weighed in on the fact that a lawyer should be sensitive to that and really has a duty and a professional responsibility to make an assessment of whether the disclosure of that information would be embarrassing or detrimental, and leaving it on the lawyer. And also the language is not a shall, it's a should. So that makes a difference also.
It looks like Bill gave me the thumbs up. So I'm going to get to Warren and Jack. I know you both have questions. There was a question in the chat by Fran. Would this rule apply to a deceased client? Obviously, you can't get consent, but are you still obligated to not disclose detrimental information?
I think if I was asked that question, my advice would be, one, yes, it does apply to a deceased client because it's client information. So if it's publicly disseminated and so forth, then I guess that would apply to this carve out. If the information, if the disclosure would be detrimental to the client, I guess that's one of those things where it's got to be a case by case sort of evaluation. The disclosure of information that really is about a deceased client, if that's going to somehow be detrimental to the client in terms of the impact on that person's family, their estate, it's hard to kind of dream up the scenario right now, but I think that's something that a lawyer would have to determine exactly how is this disclosure going to potentially impact this person, even if they're deceased, if it's going to be somehow detrimental to that person and their interest, particularly the interest that I was attempting to serve while being their representative, then I think that's a consideration. Now, I do think that the fact that the person is deceased probably is a factor, right? It may not be as embarrassing or as detrimental depending upon what the information is. And so that's why it's kind of hard for me to answer that specifically. I know I'm kind of just beating around the bush here, but I think it's because each situation would really need to be evaluated on its own merits.
I think the answer is yes.
Bill still has his hands up. I assume he still has his hand up. Pop back on if you have another question. Warren, I've got you as the last hand up.
Sorry, I guess the only thing I wanted to say, and I hesitate to dance on the head of a pin with Brad, but I do think Rule 1.9, where it discusses how the duties that a lawyer has to their former client with regard to confidential information is what, I mean, that's where you have to go when you're considering whether to sue a former client, which lawyers are allowed to do in certain circumstances. Whether that's wise or not, that's a different question, but whether you can or not under the rules, you can. And you have to go to Rule 1.9 and to look at that. And there's where we tell you what you can do with confidential information when you are dealing with a former client. And so I think that what the committee has done here kind of addresses that concern, but I don't, I completely understand how, if I'm looking for the definition of confidential information, I'm going to go to confidential information. The Rule 1.6, I agree with that, Brad, absolutely. But I just, I mean, the concept of duty of loyalty is kind of inherent in every rule, and as is the duty of confidentiality. So I think you've got to be very careful about not just going to one rule ever when you have a complicated thing. And so, I think it's I think it's good as is.
And sorry to kind of jump in here, but one thing that I just remembered as far as the drafting process, when looking at 1.6 and looking to see if this should be an exception under 1.6b, I think one of the issues that Suzanne and I ran into was it didn't seem to fit naturally with how we would draft it, and kind of the exception or the impact of it potentially being embarrassing or detrimental. And we were also relying on the language that's currently in comment 1 that instructs lawyers with regard, you got to look at 1.18 for a lawyer's duty with respect to information provided by a prospective client. Look to 1.9 for their responsibilities with respect to a former client and so forth. So, it is it is kind of directed in the comment already to say, how you reveal or use information, look to these other rules with regards to the specific type of client you have. And that was, again, maybe it was one of those things that on that given day, it did not feel like it fit as cleanly in 1.6b as it did in 1.9, which led to kind of the reasoning in the proposal here.
Bill, your hand is up. Do you have an additional question or comment? Okay. Just want to make sure. I do not see any other hands up or comments. And so we have a motion to publish as presented in your materials that has been made, and a second. So we're going to vote on that motion.
All right, and it looks like we have a 21-2 vote in favor of the motion.
All right, so the motion passes and that will be published, correct?
Yes, we'll say it's going to go to executive committee. If executive committee approves it, it'll go to the full council for publication.
All right, so I have done my job. I'm going to turn it back to Evan to wrap us up.
Catherine. Thanks for getting that through. This has been a long-suffering, hard-working committee, and Suzanne and Brian and all the other committee members have just done a great job. So I think that's it. I don't think we have no new inquiries. We have no ethics inquiries. And so we've got a list, Brian, Suzanne, and Nicole, of submissions to the council that'll have to go up through the executive committee, I'm sure. But
yeah, so basically for everyone's kind of, I guess, as we're wrapping up, we've got 3 opinions that have been recommended to the council for adoption. So those will be on the council's agenda tomorrow. And I believe there are 2 opinions that are going to be published by the committee. That needs no further action. I'll also be including all that in the council materials, as well as the rule amendments that we just were discussing will go to executive and potentially the full council tomorrow for publication. It's a lot of action today.
Yeah. Glad we didn't have any new inquiries to get through.
Right.
But they're coming. They'll come. So I think that's it. I don't think we need a motion to adjourn. I think we just adjourn and everybody have some lunch and stay healthy. And thank you all. This is a great group. Look forward and seeing you in April in person in Raleigh. Thank you.